counsel for the petition for an adjournment in the matter on the ground that he is indisposed. Prayer is not objected to by the learned counsel for the respondents. Accordingly, registry to list this matter again on after 2 weeks on a deputy fixed point.
Lordship, the belongings.
The matter be not treated as part of and or tied up matter with this court any further.
May I please? I beg to mention an read petition for listing for admission, Mike.
Give it to her, she will take this. Any motion?
Motion, madam.
What is the urgency?
It's a contempt case, my lord.
Contempt case.
Yes, pensionary benefit.
May I please, Your Lordship? So I beg to mention item number 8. In this matter, Your Lordship directed me to prepare a list for the casual and employees. The list given by Mr. Borlo, the difficulty is that there are persons appear, multiple persons with the same name.
One sometime.
I sometime because they are after 3 weeks I needed, Lordship.
You are not in the case.
Not on behalf of Mr. T.J. Mountain.
A prayer is made on behalf by the learned counsel for the petitioner for an adjournment in the matter so as to compile the list of compile a list incorporating therein the benefits received by each of the petitioners in the present writ petition. He submits that the list has already been furnished
Yes,
by the learned standing counsel
Co-person
department. However, on account of multiple entries of names of the petitioners, of the persons in the said list, some more time is required to finalize a list of the petitioners appearing, petitioners in the present process. Prayer accepted. How long will you take?
3 weeks, Lordship, after last part of
Registry
August,
to list this matter again on 18.
Lordship.
18/8/2026.
Masabu.
May I please, Your Lordship? May I please, Your Lordship? I beg to mention item number 9, Lordship. Kindly adjourn the matter for the day, Lordship. And fix after 2 weeks, Lordship.
Why?
Lordship, the record of the case, Lordship, with one H. Talukdar. His name is shown as causeless, Lordship. And he is appointed as PP, Lordship. And he is another.
You should have circulated a.
Kindly for today, Lordship.
Madam, just be here. I'll not pass any adverse order. Just be here when the matter is called.
Obliged, Lordship. May I please, Lordship?
And if you have informed the other side, kindly tell them the court is taking up the matter. I have to ask them something.
May I please, Lordship? Lordship, I beg to mention, list the matter for admission.
May I please, Your Lordship?
I have also similar prayer.
All listing matters, give it to her.
Number 31, Lordship. I prefer adjourn this matter. It's calculated, Lordship. Adjournment slip.
Why? Oh, you have circulated
Yes,
that.
Lordship.
A prayer is made on behalf of
PJ Doctor.
Mr. PJ Doctor for an adjournment in the matter on the ground.
After 2 weeks, Lordship. Late by senior counsel PK Goswami, Lordship.
PJ Doctor for an adjournment in the matter on account of person inconvenience. Prayer accepted. Registry to list this matter again after
2 weeks, Lordship.
after 3 weeks.
Obliged.
May I please, Your Lordship? Lordship, with regards to item 41, Your Lordship. My senior Mr. K.N. Chaudhary could not devote time to the file, Your Lordship. Therefore, I kindly seek some accommodation. Sometime next week, Your Lordship.
The counsel for the parties submits that on account of personal inconvenience and the matter be adjourned today and be taken up after a week.
Lordship, may fix a date, Your Lordship. 23rd.
23.
Masul.
Also, as agreed to by the learned counsel for the parties, registry to list this matter again on 23/7/2026.
Masul.
Lordship, I beg to mention listing of a writ petition for motion, Lordship.
What is the urgency, madam?
Lordship, matter relates to appointment of Gauhati, Lordship. Where
Let me
the
file.
petitioner has not called for interview, Lordship.
When was this advertisement issued?
Lordship, on Monday, Lordship.
Give it.
Yes, Lordship.
Next time you come with full facts.
But please, Your Lordship, I beg to mention item number 10. With the consent of the other party, we have also circulated the adjournment slip. Second adjournment on this matter.
Why?
Lordship, we need for further instruction. The learned counsel on record is also not available today because for the
So PD Nair is not there.
PDNI is not in the counsel on record Bangla is also not there. And the
On the
learned,
prayer of the learned counsel for the petitioner, comma, the matter stands adjourned, registry to list this matter again on 4/8/2026. Serially, material, might could you? 1 and 2. 1 and 2, I am reserving it. Huh? 3, I'll pass the order. 3, we are giving it from the date he has completed the, what do you call that? The PhD degree from that day.
I little pair in case of item number 23 little accommodation I will be online in the Punjab and High Court important matter if it is
Okay, we'll have it on some other day.
loss.
You have informed the others.
No loss little accommodation
Okay, fine.
little accommodation loss.
23. Motion material. Piece of matter. Yes, have you got your?
Yes, my lord, I have got the instruction right now.
Paisa nahi.
Actually, the problem is that, my lord, the appointing authority is the Director of Health Service. But the post where the petitioner is seeking for posting, my lord, that falls under the Director of Medical Education in GMCS. That's why DSS has already communicated to
Siblings. Both are siblings under the health
siblings,
department.
but with autonomy power, my lord. And they have already communicated, my lord. DME has also sought for the vacancy.
Vice Principal GNM Training School is, no. Where have you been posted to?
I have been posted to Gauhati Medical College, Your Lordship.
Oh,
No,
you
no,
were working in?
I was working in
Where
GMCH,
is the order of transfer?
not transfer, Your Lordship. This was a posting on promotion, Your Lordship.
That's what, where is it?
Yes, Your Lordship. That is at page
48.
41. Oh, 48, sorry, Your Lordship, 48.
Your name is at?
My name is at 44, at page 50. The penultimate one, Your Lordship. The second from the last.
This order is issued by your Director of Health
yes, my lord.
Services.
Posting is made by the Director of Health Service.
Oh.
He is the appointing authority.
No.
But since the post,
No, that's what she wants. She does not want to go to Jorhat. She wants to be retained at Gauhati because of her problems.
and because of that, my lord, that communication says, my lord, DSS has already written to the DME, my lord. On 15/6/2026 itself, my lord. That letter is
Copy soft copy.
yes.
Where are you now, Mr.?
I am in GMCH, Your Lordship.
And that communication from the DSS, that also, my lord, states the condition of the petitioner, my lord. It was a DML.
Now, this order is of 23/3/2026. Earlier on. You have not taken any steps thereafter. You have only taken steps on 15/6.
Yes. my lord.
But Mr. Now, is there a vacant post available?
Yes, Your Lordship.
Huh?
In GMCH, the maternal post
Available.
is lying vacant, Your Lordship.
Vacant.
Yes, Your Lordship.
Mr. DP Bora, Learned Counsel for the Petition, Learned Standing Counsel, Health Department, has placed on record the instructions received by him from the Director of Health Services, Assam. A perusal of the said instructions would go to reveal that although the Director of Health Services is the appointing authority, comma, the petitioner being posted in a medical college, comma, she comes under the administrative control of the Director of Medical Education Assam. It is submitted that the Director of Health Services Assam has already forwarded the matter to the Director of Medical Education Assam for taking further necessary action in the matter, and also for divulging the vacancy position of a vacancy position against the cadre of matron at Gauhati Medical College and Hospital for taking further action in the matter. Mr. Singha, learned counsel for the petitioner, submits that a post of matron is presently lying vacant in Gauhati Medical College Hospital, against which the petitioner can be accommodated so as to enable her to provide for the necessary care and attention required by her ailing mother. Mr. Singha also points out that the petitioner is the only person available to look after the mother, look after her mother, and the mother's condition is such that she is not in a position to be taken to Jorhat Medical College. Also, accordingly, Mr. Bora is directed to receive instructions as to whether any vacant post is presently available, vacant post of matron is presently available in Gauhati Medical College Hospital. In the event any vacant post is so available, the respondent authorities, until further orders of this court, shall accommodate the petitioner against the said post, promotional post of matron, and thereby facilitate the petitioner to discharge her duties as well as to provide the necessary care and attention to her mother. Also, it is also provided that until a decision is taken in the matter with regard to the promotion of the petitioner against the vacant post of matron in Gauhati Medical College, if so available, the petitioner's services in Gauhati Medical College shall not be disturbed. Registry to list this matter again on 22/7/2026 to facilitate Mr. Bora to complete his instructions. Anything more required?
No.
But that smile is not coming. Now,
Anyway, I'm deeply obliged, Your Lordship.
never be apprehensive. This
No.
court has this bad habit of poking, but don't be apprehensive.
No, I'm not, I'm never apprehensive, Your Lordship.
But your face does not divulge that.
Maybe
Therefore-
because of instruction, proper instruction.
I think now the complaint will not be there anymore. I have given it. Anyway, deeply obliged, Your Lordship.
Obligement.
It beats to us, 20. What? Good. Submit proceed. What happened? I made a mistake yesterday. That writ petition would be maintainable.
Yes.
I made a mistake. I was going by the citus of the place of working, but Article 2262 and 20 of the CPC. Here he comes in.
Cause of
I
action,
made a mistake.
partly, yes, sir.
We can also make mistakes. We'll take it up along with the supply items.
Yes.
Public is. Yeah, automatically. Mr. Kaushik, if you can send somebody
Yes.
petitioner.
Lord, this matter, your lordships directed us to produce the bank's record.
Mm.
My lord, we have intimated them, but till date, my lord, we did not receive that.
Then we'll have to draw adverse presumption with regard to that.
My lord, can I pray some more time? My lord, what happened, my lord, earlier, it was with the United Bank of India, which is defunct body now. Now, where they have put the record, the Punjab National Bank have been requesting them, but they could not get it. it was dislocated, my lord, somewhere. Earlier, it was in the head office of United Bank of India.
Mr. S. Dr. Learned Senior Counsel representing the Punjab National Bank authorities, respondents, submits that the records are being traced out. He submits that the departmental proceeding against the petitioner was carried out by the erstwhile United Bank of
United
India.
Bank.
And after the said bank was merged with the Punjab National Bank, the records have been misplaced. However, he submits that all efforts to trace out the records are being made, and he is of the view that the said records can be produced on the next date of listing. He submits that the matter be taken up on.
Your lordship may give a
No, you
bit long.
heard it. You give it. Your
After 4 weeks, my lord.
on today is 16th, on 18/8/2026, by which time the records shall be placed before this court. Also, in view of the above submissions of the learned senior counsel for the respondents, registry to list this matter again on 18/8/26.
Much of this.
No further time shall be granted for production of the records. Also,
Obliged.
but Mr. Counsel, you have taken a lot of pleas with regard to, even with regard to the your defense assistance.
Yes, well.
But you have not denied the act you have done.
No, in the
You
reply,
said that because they have in the inquiry brought on record. I just want to look into the statements of the witnesses, that's all. They have established that you made the debit. Either you were the person entering the matter or approving the matter. And you had made deposits in your wife's account. When it was detected, you had withdrawn the amount. So these aspects, when you are a bank employee, the level of trust is much more than that of a common employee.
exactly.
Just look into that aspect of the matter. Because Mr. Doctor will come hammer and tongs on you on that point.
I'll try
Obliged.
to well defend.
Obliged.
Ah,
The husband of the applicant, my lord, was working under the respondent,
why should we entertain this writ petition?
my lord.
Why should we entertain this writ petition? One ground,
Because they have, my lord, dismissed the husband of the
that they
petitioner.
have said that is an error subsequently. In
My-
the affidavit, they have said that that is an error, that should not have happened.
But-
Then what?
But they have, my lord, stated that the person will be having lien, my lord, for 5 years. So before that, prior to that, my lord, date in the 31st of March 2029, he expired. So, my lord, they have also, facts was also known to them. Some of the, my lord, 39,000 something has already been released, my lord. So now, my lord, because already
Still,
expired,
you are not coming to the point.
what lordship is maybe
Yes, madam. Why she should not be entitled to pension? Family pension? You are the CGC.
Yes,
Yes, why she should not be entitled? What is your name?
on behalf of.
on
SP
behalf of
Chaudhary.
SP Chaudhary.
Where is Mr. Chaudhary?
Due to some medical issues, he is out of station.
Should have circulated a memo.
At the morning only, I am informed by my
You are
senior.
prepared.
No, lordship.
When is he coming back?
By this week only, I think.
A prayer is made on behalf of, heard Miss Udas Learned Counsel, Miss Udas Learned Counsel for the petitioner at some length. A prayer is made on behalf of Mr. S.P. Chaudhary for an adjournment in the matter on account of person of medical, on the ground that he is indisposed. Also, prayer accepted. Registry to list this matter again on 21/7/2026 for further hearing. See, tell Mr. Chaudhary to demonstrate before this court he was only declared a deserter. He was never terminated. So the whole period of his service will now have to be regularized, and the lady is entitled to pension.
Maybe on 16 or 23rd, my lord, 21, I have.
23.
23.
3.
Already clear.
Loveless.
You find out judgments.
Lordship, because only yesterday I could come to know regarding listing of this case, my lord. If you have license.
As the was supposed to appear, Lordship, he's on,
Huh?
as the was supposed to appear, he's on legs, Lordship. However, he informed me, Lordship, that he could not contact the client, Lordship.
We'll pass orders.
It's Lordship,
We'll pass orders.
Lordship,
Where is Mr. Doctor?
he's on leg, the input.
Call.
Lordship.
Where is the counsel for the corporation department? Mr. Bodle.
Is there.
Where is Mr. Bodle? You are paying for?
Legs. My lord, he's on legs on another court.
Mr. Bodle,
Yes, sir.
call it. After some time. Amount deposited?
My lord, just 3 months remaining, my lord. We are paying these amounts with the funds that are being provided by the.
Who is there for the PF?
Yes, my lord, today.
Mr. Roy, you appear for the PF department? Provident Fund? Regional Provident Fund Commissioner?
I can obtain instruction.
And I have appeared for the first time today in this case. Earlier, it was not listed since last more than a year. This is the latest position, my lord, the instruction that I received yesterday.
Oh, bank.
ASTC.
The ASTC 20 crores was directed to be deposited. You had stopped their operation of their bank account and they filed this writ petition. There was an interim direction that they will deposit some amount. And accordingly, no coercive action was directed to be taken. Sometime on 15/11/2018, the petitioner has submitted that around 12 crores was deposited. And they had said that they are getting around 25 crores from the government. So by that time, the budget session was next 19. So after that, they will do the deposit. And today, Mr. Chomuha submits that no, we are not concerned with this.
Kindly see the second, third paragraph. At present, ASTC has outstanding regular PF contribution.
No, where is the impugned order? Impugned order is for the period.
The annexure 1, my lord. There are many, there are huge dues, my lord.
Period 2.
Period or,
No, have you cleared this dues? We have
yes,
cleared-
only just 3 months remaining.
Which?
That is instruction says, my lord, kindly see.
No, what is the period of no, we are only concerned with the demand made by you here.
The demand that was paid, my lord.
Then what is left now?
No, my lord, still there are 3 months remaining of 2023.
That we are not concerned.
Oh, correct, that is true, my lord.
We are only concerned with the dues which have been claimed in 2018.
My lord.
So has this dues been
Yes, my lord. So
liquidated?
far this instruction is concerned, so everything is paid.
So Roy, can you have that instruction?
I can.
There is nobody representing the.
If nobody has appeared earlier, my lord, I can obtain instruction.
My lord, I will provide him a
No,
copy of
your
this.
name is on Mr. P.K. Roy, Miss A. Chakraborty.
Or then it is not shown in the cause. So therefore,
Mr. Nondi also appears. KK Nondi. You are for the State Bank only.
If no affidavit is filed, my lord, I'm not sure whether an affidavit is filed in the.
No.
Yes, affidavit is filed. my lord.
Affidavit assistant.
Assistant
Madhurima
PF
Dutta.
Commissioner.
Who is
Oh,
Madhurima?
my junior, my lord,
Okay.
junior. She has filed it.
Okay. Raised, heard the learned counsel, heard Mr. H. Chamua, learned counsel for the petitioner. Also, it is seen that the name of the learned counsel representing the regional provident fund commissioner, that is the employees, the employees provident fund organization, that is the response number 2 is not reflected in the cause list. Also, registry to list this matter reflecting the name of Mr. P.K. Roy and Ms. A. Chakraborty as learned counsels for the respondent number 2 in the cause list. Registry to list this matter again on, let us have it on 22nd. You have this instruction.
Lordship.
Give him a copy. also.
My lord, I'm-
And Mr. Roy, if they have liquidated the amount which is claimed in the present thing, subsequent what happens, we are not concerned. For that, you can have your own proceedings. But 2018, if they have 20 crores was demanded, if they have liquidated that amount, then that's the end of the matter. 22/7/2026, huh? For further. 22/7/2026 as a top of the list item.
deeply obliged.
Yes.
I'm appearing for 12, my lord. I have no contact with my client. That is a removal order was challenged, my lord.
Rightly removed.
But
Rightly
second
removed.
case is
Mr. Roy,
for-
you are appearing for?
For the PF, PF is made party here.
Or for his dues?
Yes.
You can be a spectator.
PF made.
You can be a spectator. Yes, what is your ground? Nothing. 7 lakhs, you yourself gave a receipt. And the
Accepted.
finding conclusion of the criminal proceedings, those evidences were never placed before the criminal
Departmental
court.
proceeding.
So that judgment will not help you.
No, that is.
And what are the 2 cases?
Second case is, my lord, I'm not appearing in the second case.
Who is appearing?
Your Lordship, I'm appearing for S Islam. S Islam, Your Lordship, he is out of the station.
Can't help it. Make your submissions. You are appearing in 7759/2018
18.
and 1050.
That Islamic. Second case is, I think, for some money.
Actually, the second case,
Some
my lord,
countries,
this challenge the impugned decision of board meeting. And after that, request for reimburse the deducted amount. That's the second case.
Or that you made a deposit, recovery of that 7 lakh,
Yes,
7 lakh.
and then you return 3 lakhs.
yes, based on the board meeting decision.
Oh. Where is Mr. Islam?
He is went to Gwalpara.
You could have circulated a memo yesterday. He's coming tomorrow.
He is making the next week, I guess, because he's taking 2-3 days.
Heard Mr. J. Sharma, learned counsel for the petitioner at some length. Also
L
heard-
Deca on behalf of M. Datta.
Also heard Mr. L. Deca, learned counsel appearing for the
2 and 3.
Assam Tea
2 to 4
Limited respondents. Hearing remains inconclusive. Registry to list this matter again on Monday, 20,
Obliged.
as the top of the list item. 20 as in 21. 21 Parikh. Jundina Parikwa. 24. 24/7. We'll have to dismiss this. Only we'll hear Mr. Islam for that part.
Obliged.
Regularization,
Yes, my lord.
29-7.
29.
As agreed to by the Learned Council 4040, so registry to list this matter again on 29-7. Yes, Ms. Bora.
In physiology. My lord, petitioner was enrolled on 28/10/1998 in Assam Rifle. As rifleman or
Are
sufferer.
you keeping well? I'm not hearing you. What's it? Yes.
Petitioner was enrolled in Assam Rifle on 28/10/1988, my lord. What happened, my lord, in the year 2017, my lord, he was suffering from, my lord, diabetes.
Diabetes and cross-fused kidney.
Yes,
So you were in shape P2.
yes, my lord.
So you were not given an extension. What is the error?
Yes,
What is the error?
son there, my lord. I am getting pension. However, as I was discharged from service, my lord, at the age of 54 years, not 60 years, my
You
lord.
completed 30 years of service.
Yeah. So, my lord, I am entitled to some, my lord, compensation. Lump
What
sum,
compensation?
lump sum compensation
Where is that rule with
In
regard to
lieu-
compensation?
in lieu of disability pension. As I became disabled, my lord.
You have not been disabled. That reason is not attributable to your service. There is a clear finding of the medical board to that effect.
That is not there, my lord, because they have said that, my lord. If, my lord, at the time of, my lord,
Show me the
enrollment,
provision, show me the provision which entitles you.
at the time of, my lord, I was well. So if I became disabled, my lord, this means that it is attributable.
See, this disease is not attributable to the service. It's diabetics and the consequential effects of diabetics. That cannot be attributable to the service. You show me that it is attributable, I'll direct them.
My lord, only, my lord, lump sum compensation in this regard.
Madam, you show me the rule, show me the provision which entitles you to that.
As per disability, my lord, rule, I am entitled disability pension, but
Show me.
one thing, my lord, some documents, my lord, some similarly situated persons are given like me, my lord. Can I show this document?
And they have taken so much pleas in the affidavit, you have not even cared to file a response to that.
There, my lord, you will get, my lord, disability pension along with his own pension, my lord. Only lump sum compensation, my lord, not full pension he is getting, my lord, as because he has been prematurely retired.
In all these documents, there is a clear-cut finding that the disability was on account attributable to the service of the petition.
My lord, any disease, my lord, developed in the service, my lord, that is always attributable, my lord.
You show me that this is attributable. This judgment is also locomotor disability acquired during service
Yeah.
in the Supreme Court decision. This decision is only to the effect that whether it will be locomotor persons will get it because it was only given to visually impaired persons. So this decision will not help you. This is of our Supreme Court.
Yes, my lord. My lord, even they have not given my medical board is to be conducted in see my answer. They have not even in 2025, 2020.
Just a moment, just a moment.
My medical board was due.
Who is appearing for the respondent? You are appearing.
DC Bora's name is there.
Where is
So,
Mr. Bora?
Mr. Bora, he is suffering from some problem, not regular, probably, Lordship. Lordship may fix it on a short date, Lordship, because we have already circulated in our group also that matter is going on, but till now no one is here.
Not Mr. Miss S. Bora. Not date yes. Date for the 3 तारीख को आता. As Bora, learned counsel for the petitioner at some length. There is no representation on behalf of the respondents. For the ends of justice, registry to list this matter stands adjourned today. Registry to list this matter again on 31, 7, 2026 for further hearing. We'll consider.
Also, Lordship.
Okay, let the learned counsel. If we want your assistance, then we'll see. Yes.
Well, the issue is related to petitioners participated in the selection process at Tezpur, my lord, and he was selected by the authority, my lord, and he was dispatched for training, my lord. Subsequently, after 180 days, he was declared as unfit. If you order is that, my lord, page 21, your lordship, cancellation of candidature.
What is the error here?
Error, my lord, since my lord, first initially they were selected, my lord. And
Fine, that was not
subsequently,
detected.
after 180 days, they were declared as unfit,
No,
unfit, my lord. And under
after
the,
180 days, he was subjected to further medical examination.
if 180 days is over, my lord. In that case, my lord, after receipt of the, all the documents, my lord, there is across the 180
They
days.
say that
So-
between the rally and the subsequent, before the appointment, there was a gap of 180 days.
180 days, my lord, there is a gap. And under Rule 13, my lord, which I have been relying, my lord, it should be done by the invalidating board, my lord. And in support of my submission, my lord, Rajpal Singh's case, I will rely, my lord.
And what is the second case?
Second case is the same, my lord. Both of them participated.
No, varicose vein.
Varicose vein, my lord. In fact, my lord, they have not given any opportunity also.
Yes, what is the decision you want to rely upon?
Rajpal Singh's case, my lord, page 23, 24, my lord. And one of our High Court's judgment, my lord, I have denied, my lord. Twenty-two, 23, and Rajpal Singh's case, my lord, 22, 23, and 24, my lord, I am relying, my lord.
23 and 24.
To be carried out only on the recommendation of invalidating board. But in my case, my lord, in fact, in their counter affidavit also, there is a contradictory statement, my lord. And in our High Court also, my lord, it is in respect of a overage, my lord, he was subsequently found overage, my lord, at page.
No, this Rajpal Singh is in respect of an enrolled officer.
Exactly, my lord.
You are not an enrolled officer.
I am not enrolled, but I am selected, my lord. That is my,
Selected and enrollment are two different things.
and in respect of our High Court judgment 2016 to GLT, my lord, here, my lord, they were selected but subsequently unfit, my lord, for the medical cert phase 20, 21, and 22, my lord. He is found to be overage, my lord, during the review medical, my lord.
This is nothing to do with medical. They review medical board held that he was overage.
Overage, my lord.
Then the court said that no, the review medical board cannot go into any other aspect other than the aspect of medical position situation. Oh, how does with this help you?
And in respect of, my lord, counter affidavit filed by the authorities, my lord, that is. Here, my lord, initially, my lord, they were, when they were dispatched page para 7, my lord, they have stated, my lord. The lordship got it. Counter affidavit. Para 7, my lord. With regards to the statement made in paragraph 7 of the writ petition, deponent states.
Paragraph 6 of the writ.
Para 6 and 7.
Sorry.
Lordship.
I'm looking into your reply.
WBC number 6095. Para 6, 7, my lord.
6, Yes, read.
With para 6, my lord. With regards to the statement, writ petition deponent states that recruitment rally medical was held on 19 February 2000. He was found unfit. Then he was referred to 155 base hospital review where the specialist declared him fit. The petitioner documents verified completed on 11 September 2000. Accordingly, he was called for dispatch to regimental center on 19 September 2000. Thus, there is a gap of more than 180 between the rally and the medical and dispatch. As per call letter 31st May of 2018, read conjunctures with para 221 Director General, Directorate General of Recruitment Directorate and Medical of the candidate is required to be done if there is a gap more than 180 days between the rally medical and dispatch. Hence, the remedical of the petitioner was carried out by recruiting medical officer and reviewed by the senior super recruiting medical officer of the headquarters recruiting zone Northeast Shillong. Further, petitioner was referred to medical hospital Shillong for graded specialist review. All three medical officers specialists found the petitioner unfit disability of Biscore bands left leg. Hence, as per procedure policies in back, the candidature of the petitioner was cancelled. And then para 7, my lord.
Seven, they say that because at that time it may not be that much aggravated, so you may have been declared to be fit. But subsequently in the review medical board, it was found that it has aggravated.
But in Biscore Ben's case, my lord.
Have you denied that you were not having varicose veins? Varicose veins has a restraint effect on your movements.
That's true, my lord. But Biscore Ben, if someone has, since my lord, I have been Biscore Ben, my lord, in that case, walking and other things, my lord, I have been found disturbing, my lord. So far as I have
It will be
just
disturbing.
gone through the medical
Treatable.
opinion. my lord.
Nowadays it
So-
could be treated, but in 2018, I don't know whether it could be treated.
After
But-
3 months or 4 months, my lord, someone has suddenly Biscore Ben and other things, my lord, they ought to have through a specialist medical team, my
They
lord.
have sent you to the medical hospital for graded specialist review. And
Referred
they-
55 base hospital.
Okay, let us see how you have dealt with para 6
Para
in your
7.
reply.
Since my lord, 155 base hospital found him fit, my lord. Within 6 months, my lord, someone is fit, and then 6 months later, he is found to be a Biscore Ben, my lord.
Have you raised this issue before the authorities?
My lord, yes, I have filed the appeal, my lord. Then appeal was also decided, my lord, and they have asked me to reappear, my lord. In the appeal, my lord, appeal order is at, my lord, in their counter affidavit, my lord, page 17, my lord. Page 18, para 6, your lordship found that if I am a Biscore Ben and unfit, why they have called me for again for appearing in the rally, my lord? Once declared a person unfit.
Where is that?
Page 18, my lord. Page 18, para 6. With respect to your request for reconsideration of your candidature, it is to inform you that once disability is confirmed and candidate is declared unfit by the specialist, thereafter there is no such provision to reconsider your candidature. However, you are hereby advised that you may reappear for forthcoming rally, which is scheduled to be held on January 2020, if you meet the requisite criteria.
If you meet
Then
the
again, my lord,
requisite criteria.
that
You're
up to
dismissing it. Can we record your name? Or we'll say none appears for the request. None appears for this.
only thing, my lord, my prayer is that let them reconsider my case, my lord, through a specialist doctor, my lord. Since, my lord, after 6 months, my lord, after 6 months, my lord, I have been declared.
There is one order I have to pass at 2, thereafter I'll pass this order.
2 o'clock, my lord, I have to there.
Need not be. No one should be here. We'll pass the order.
Obliged, my lord.
And see the time gap now.
My lord,
18. We are in 2026.
but there is no point. They can consider my case, my lord. That is my prayer only.
Here, madam, I'm against the order of reduction of one stage time scale of pay for a period of 1 year. The basic allegation against me is that, my lord, during a transit,
that five
bulletproof jackets were missing, my lord. That is the allegation, my lord. And it was supposed to hand over in Gauhati, but the person concerned, he did not contact me, so I could not deliver in Gauhati, my lord. Then we went to Karnataka, and during transit, it was missing.
It was kept near the door, and then
Yes, my lord.
somebody stole it. But it was in your custody. 5 bulletproofs are 5 lives.
Yes. But that bulletproof jacket was expired in the year 2011, my lord, as per their report.
And the transit was in? When was it handed over to you?
It was handed over to me, my lord. Page 22.
Where do I get that it had expired in 2011? Where do I get it?
That page 17, my lord.
17.
17. That is my statement, my lord.
No, is there any material? Have you projected that before the inquiry? In the inquiry, have you projected that?
During inquiry, my lord, that because computation was made thereafter, my lord. After the inquiry, the computation was made, my lord.
No. I'm on the expiry thing. If the thing had expired in 2011,
yes,
a loss can be condoned. Where do I get it in the inquiry proceeding that this was taken by you? This plea was taken by you?
For that, my lord, I need some time, my lord, to find it out, my lord. Because in the pleadings that was pleaded, my lord. But the
Para 35.
Para
35.
with
Para 35.
Purchase on 1996, same had been expired on 2011, which came to the knowledge of the petitioner. And that was not denied by the in their reply, my lord. They have said that, my lord, the averment made in para 35 of the written is baseless because expiring the validity date of the government items cannot be thrown out until and unless property condemned by a board officer. Further, even after expiry, there has been certain process to dispose of such government items. Hence, the averment made by the petitioner in the instant period cannot be proved to him be innocent.
But you did not raise this plea in before the inquiry officer.
That fellow, I have to find it out.
Find it out.
I'll find it out.
On the prayer of Mr. N.J. Khatunia, learned counsel for the petition, matter stands adjourned. Registry to list this matter again. 24.
Yes,
24.
Obliged.
As the top of the list item. Mr. H. Gupta, learned counsel for the learned CGC appearing for the respondents is present. You also examine if the material is already expired, then what is the point in subjecting him to a punishment? Maybe a warning or something can be given, but recovery, then again,
a major punishment, madam.
Major punishment, cumulative effect.
Yes, madam.
Cumulative, future, postponing future.
So that will not be called for. You also take your instructions. Mr. Gupta, before the next date of listing, I got to keep it. Mr. H. Gupta, learned counsel for the petitioner, shall receive instructions with regard to the contention raised by the petitioner in para 35 of the writ petition to the effect that the bulletproof jackets which were handed over to the petitioner had lost its utility as of 2011. It is projected by the petitioner that the said jackets were purchased by the force in the year 1996, and the same had a validity period till 2011. Mr. Gupta shall on the next date of listing apprise this court as to whether in fact the validity of the said bulletproof jackets had expired in the year 2011.
Obliged.
For further hearing, but Mr. N.J. Khatunia for at some length. Yes.
Yesterday, you're also directed to produce the proceeding file, my lord. I flag marked the statements of the witnesses, my lord.
Lordship, may I make one submission, Your Lordship? Your Lordship may kindly come to page 56 of my petition, Your Lordship. I am basically aggrieved by, Your Lordship, one punishment, Your Lordship, that is page 56(3). This is not a punishment, Your Lordship, prescribed.
In case of any claim.
Lordship.
That much only.
That much only.
Lekha.
Also, there is a provision for appeal also. The petitioner has not.
19 order.
Yes, sir.
19 order.
There is a provision for appeal against.
Only that.
Only that, Your Lord.
But Mr. S. Bhattakur, Learned Counsel for the Learned Senior Counsel, assisted by Mr.
D.
Gogoi, Learned Counsel for the petitioner. You are appearing for Mr.
1 and 2.
How many respondents are there?
2 respondents, my lord.
Only 2, Your Lord.
Government?
Government.
Mr. A. Chakraborty. Also heard Mr. A. Chakraborty, Learned Counsel for the government advocate, appearing for the respondents number. No, you're not there.
No, Your Lord, only 2.
That's why I got confused. Also heard Mr. H. R. Shekhar, Learned Counsel, appearing for the respondents number 1 and 2. The present writ petition has been instituted by the petitioner assailing an order dated 12/9/2019, passed by the Managing Director, Assam State Warehousing Corporation, Warehousing Corporation, imposing upon the petitioner a penalty of withholding of 1 annual increment without cumulative effect, along with certain further stipulations. In pursuance, on conclusion of a departmental proceeding instituted against him. Mr. Bhattakur at the outset has submitted that he would not press the present writ petition with regard to the penalty of withholding of 1 annual increment without cumulative effect as imposed upon the petitioner. However, Mr. Bhattakur submits that the further stipulation made in the said order of penalty dated 12/9/2019 to the effect that in case of any claims made by any depositor in future, the same would be liable to be recovered from the petitioner, would mandate an is being pressed, is being assailed, and the same would mandate an interference from this court. Mr. Bhattakur submits that the said stipulation as made in the penalty order dated 12/9/2019 is not a prescribed penalty, and the same could not have been incorporated in the order dated 12/9/2019. Yes, what do you say?
Lord, so there is a provision for appeal also, my lord.
No,
Once the
forget the
punishment is
appeal.
given, my lord.
Forget the appeal. You tell me about this. Is this a penalty?
No, it is not prescribed, my lord.
Mr. R. Shekhar, Learned Standing Counsel for the Learned Counsel, appearing for the respondent number 1 and 2, fairly submits that the said stipulation assailed by the petitioner contained in the order dated 12/9/2019 is not a penalty and was not required to be so incorporated in the said order. So, in view of the agreement arrived at by and between the parties in the matter with regard to the the petitioner, why the order dated 12/9/2019 was issued with the following, was imposed with the following penalties. Page 56A2. As noticed herein above, the Learned Senior Counsel for the petitioner has submitted that the petitioner would not be pressing the present writ petition with regard to the withholding of with regard to the imposition of the penalty of withholding of 1 annual increment without cumulative effect, and also the warning issued to him not to repeat such mistake in future. The challenge in the present writ petition is limited to the third penalty as imposed upon the petitioner. So, as noticed herein above, the parties are in agreement that the same said penalty as imposed upon, as imposed at serial number 3 above upon the petitioner is not a penalty prescribed under the rules. Accordingly, this court is of the considered view that the same would not was not mandated to be imposed upon the petitioner. So, in the event a claim was so raised by any of the depositors in the matter, the respondent corporation was within its rights to have also moved against the petitioner by way of instituting appropriate proceedings for recovery of such dues, and the same could not have been imposed as a penalty upon the petitioner by the order dated 12/9/2019. So accordingly, the order dated 12/9/2019, to the extent of it imposing, accordingly, the penalty as imposed upon the petitioner at serial number 3, while the order dated 12/9/2019 stands interfered with. It is clarified that the penalty as imposed upon the petitioner, while serial number 1 and 2 above, it would not mandate an interference, and accordingly, the same stands affirmed. The above observations and directions, the present writ petition stands disposed of.
Deeply obliged.
Mati. Motion gita bamara. Mr. Rafiq.
Yes.
Yesterday I was on a wrong footing altogether. I'm sorry, what I said is wrong.
Yes.
The writ petition would be maintainable here. Tomorrow we'll pass the order.
Yes.
I was only looking into the situs of your employment.
Yes.
I was not looking into Article 2262 as well as Section 20 of the CPC. That's a mistake. We can make mistakes sometimes.
Yes. Natural.
Yes.
My lord.
What is your case?
My lord, that
You are ready with the instructions?
In my case, other cases come, I think that the stand will be similar, Lordship.
Yes, you have got your stand.
Regard to the ground which they have taken, that they have foregone their promotion. That instruction I have it, that after the promotion had order
there
had
was
been
nothing.
issued, there was nothing.
So if they forego, are you ready to?
If they submit, we'll consider that.
Yes. Yes.
Submit.
Yes, I'll submit.
Huh?
Yes, sir.
Then we'll dispose of the matters in that
Yes,
time.
sir. Yes.
We can dispose of.
Yes. They have not
No,
submitted.
that's what I said.
Before I have submitted.
Before we'll not do afterwards.
Before would not do
before
for one
promotion-
more reason, Miller, because since it is a transfer management module, when the notification has been issued, they participated in the process by choosing the choice of posting.
So for promotion also, you give them choices.
Yes, because it is a,
My lord, not a single choice has been considered.
it's a transfer. Transfer, promotion come transfer.
Okay, we'll just consider this. Yes, Mr. Rafiq, Madan Mohan.
Madan Mohan.
Madan Mohan was working where?
Six.
Where is the order?
Lambding Miller.
Where is the order?
46, case 46, serial, sorry, Madan Mohan.
46,
No,
serial
Miller,
number?
no. 36, serial number
36.
91.
90. You were at Lumding from when?
For the last 3 years, Miller. I have joined there.
Joined on?
Yes. In 2022, Miller.
Okay. What were your choice place of posting?
Miller, I choose 6 places, Miller.
Where do I get it?
Lambding is one of them, Miller.
Where do I get it?
In my representation, Miller.
Representation. Where is the representation?
Representation, Miller, page 53 annexes 6 million.
Okay, where is the places of posting?
Places of posting, my lord.
You are gone from Bodorpur.
Yes, my lord. Bodorpur to Sairang. And in Lamding, my lord, the posts are.
No, where do I get that? Places of posting? Choice?
Choice, my lord, in my representation,
Okay,
my lord.
come to page 55, it is there.
55, yes, my lord. Agartala, Badurpur, Koimganj, Bairangam, Dharmanagar, all this. And they have denied because they said, my lord, there is no post lying vacant in Lamding division. But the fact is that there is a vacant post, my lord, which I have annexed as annexure 8. 11 portion is.
Bodorpur is where? Barakweli.
Barakweli.
So, where is your family? Yes, where is your family?
Agartala.
Agartala. And you have not opted for Lamding.
I have opted for
Where?
Lamding also.
Agartala, Bodorpur, Korimganj.
Korimganj is under Lamding division.
Everything is under Lamding.
Lamding.
By Sairang is under?
That is also under Lamding.
That's what I'm saying. It's all Lamding.
All Lamding.
All Lamding. Doesn't make any difference.
Only the thing is that it is a
Distance,
convenience for
distance is not, that's a personal reason. Any violation of any of the statutory provisions?
Statutory provision, no, my lord.
Any violation of your, any malafide alleged?
Only the thing is that, my lord, the first 3 choices has not been considered.
That's an
make effort.
administrative. That is an administrative, because see, it's the transfer on promotion. So what do you propose? You
Yes, I
want
have-
to press this petition, or you want a liberty to approach them with a prayer for foregoing the promotion and asking
my
them to?
I will go for that.
And you go, we will protect you till that time.
Yes,
They consider.
I will
Will
go
do?
for that.
You withdraw this petition.
Yes, please.
Mr. Rufik, learned counsel for the petition, after attempting to argue the matter at some length, submits that he be permitted to withdraw the present writ petition with a liberty to approach the respondent authorities with a representation, highlighting therein that the petitioner desires to forego the promotion as ordered in his case, which had also resulted in his transfer. Mr. Rafik submits that although prior to the initiation of the process for consideration for promotion from the post of constable to that of head constable, the petitioner had submitted an unwillingness, a representation expressing his unwillingness for such promotion, no such unwillingness was submitted after the promotion was effected in respect of the petitioner hearing. Accordingly, he submits that he be granted liberty to approach the respondent. Accordingly, it is for the said reason that the learned counsel for the petitioner has sought for liberty, sought for the said liberty to approach the respondent authorities with a prayer for foregoing his promotion. The said contention or made by the learned counsel for the petitioner is not objected to by.
Here in 2021.
You just write down wherever you three are there, just write down. By so and so learned CGC appearing for the respondents. In view of the above submission of the learned counsel for the petitioner, the present writ petition is permitted to be, present writ petition stands dismissed on withdrawal with liberty to the petitioner to file an application before the respondent authorities within a week from today, within 7 days from today, expressing, if they are highlighting therein his unwillingness to accept the promotion as ordered in his case, with a further prayer to continue him against the post of constable at the current place of posting. Also, in the event representation is so preferred by the petitioner, comma, within 7 days from today, in the above lines, comma, till consideration of such representation, the petitioner be not disturbed from his pleasant place of posting. Also, subject to the above.
Not already released. Here there will be one have already released.
All thing constable, mighty RPF. Hisa? Okay. Subject to correct. Done.
Yes, madam.
Lordship had given us time to dispose of it.
That you do it as per your convenience. You do it in 1 day, you do it in 1 week, you do it in 10 days. That is up to you. Only I said 7 days he will have to submit an application. That you do.
My lord, the 21, my lord, I want to contest, my lord, not
21. Okay, we'll contest 21. So 20 gone.
21.
20, 46, 47, 48 gone. Same name.
No, for 46, 47, 48 not, that's the difference.
46, 47.
Yeah. This three.
Tinta हुआ. Item number 20, 46, 47, same order. Beleg ke mari. Yes, 21. That you give it 21.
Yeah, my lord, the impugn order, the relevant person is at page 46, serial number 204.
Page 46.
Serial number 204.
204. Okay. Upon them now.
Yes, ma'am. He has been transferred from Silchar to Tinchika division. Yeah, my lord. After 31st March, my lord.
So here you're not expressed any unwillingness for the transfer.
I have.
I have. Okay.
My lord, I'm just showing what they have violated the statutory provision. Because as per the directive number 58, there cannot be any transfer after 31st March.
This is not the same order as the other one.
No, my lord.
Different order.
Different.
This is order.
No, subject matter is same, my lord. Transfer order is same. Because he is living with his family. And your lordship, kindly see the directive number 58.
Okay, show me where you are living, where your family is.
I'm living in Silchar with my family. My child is studying, my lord. And
You are living in a quarter. Family is living in a quarter.
Yes,
Where have you stated that?
That I have not stated.
If your family is living in your own native place, native house, then the transfer of yours will not disturb them.
Within Silchar, my lord.
That is it I'm saying. If you are staying in a quarter in Silchar and then you are transferred mid-session, your children's education will be affected. But if your children are staying with their mother in your own house, how will that affect you?
It will affect, definitely it will affect, because I'm in Gauhati, my children suppose residing in Dayatpur or somewhere place, my lord.
In
I
their
can
own
look
house.
after them.
In their own house.
Maybe rented house, maybe own house, my lord.
That's
But
what
it
I'm
will
saying.
affect, definitely. it will
So
affect.
if you have been promoted, if you don't want the promotion, go and express your unwillingness to accept the promotion. Stay there if they permit you. Otherwise, that cannot be granted because for all times to come, your children are not in class 10, class 11.
No, that is for exemption. Your lordship, kindly see the provision, clause 17. There is no such thing has been mentioned. Your lordship, kindly.
This is promotion which was considered, given. And what are the options given by you?
Lamding division and Greater Gauhati.
So how will you come to Gauhati leaving your family there?
If I get time, my lord, I will ship everyone, my lord. That's
That,
why this
Mr.
provision.
Council, that is not the parameters for. So we'll consider, we'll dismiss this.
Then your lordship kindly. see
Class
the page-
6.
Class 6. Your lordship kindly see page 21. The process of annual transfer. All annual periodical transfer.
Oh, these are guidelines. This cannot be justiciable.
No, it's mandatory, my lord.
It's
They
cannot.
must follow it in letter and spirit, my lord, because it is.
Show me a decision wherein this has been
Yes,
said
my
that
lord. Odisha High Court recently passed only on.
Orissa, forget it, show this High Court or Supreme Court.
Let your lordship kindly see this directive has been framed under Rule 28 of RPF. So it is mandatory. They must follow me. Nature is mandatory.
Rule 28 RPF rules.
RPF rule. Your lordship kindly see NHA 1 page 16.
Now show me that here where it is with regard to promotion. Transfer on promotion, whether that has been incorporated here.
That is not incorporated.
Then it's a different ball game altogether. You have been now promoted.
Even after my objection.
That's why I said you go and give your unwillingness.
After the promotion. Then I will go for that.
Same order. Then next one.
Forty-eight.
48. Urup Kumar Sultan. Yes.
Here also, my lord, there's a violation.
Yes. Where are you?
17. I'm in Gauhati, my lord.
Guwahati.
On spouse ground, my lord, I have challenged this repetition, challenged the transfer order, my lord. My prayer has not been considered and transfer order was issued after 30%.
So this is not a promotion. This is not a promotion.
Not promotion.
This is normal.
Normal. My wife is also working here, Gauhati. I just prayed, my lord, at least they could have easily posted me nearby place. If there is no vacancy. That has also not been considered.
Okay, what is the ground for rejection?
Page 48, my lord. First, they have said my daughter is studying in class 8. And the provision exemption is available only for a student who is staying in class 10 or 11. This is misinterpretation of the directive number 58.
You were transferred from which place to which place?
From Gauhati to Katihar.
You are as assistant sub inspector.
Yes.
Come to clause H, page 48.
48. H. The petition was transferred from Romania to Swenso Bhai Tursotan under working couple ground.
I think this is more than a liberty that can be granted to you. You have completed more than 10 years in a single spell or 15 years in broken spells in the same station. I don't think so. You are.
No, Mala. There is no such bar, my lord. I cannot be posted back.
There is no bar in posting you to.
No, in the directive it is mentioned, my lord. There is no bar. I can be posted back on compassionate ground, my lord. And
But-
why
but-
I have.
But that was not there. That is what they say.
They said, but you also can see the directive.
Okay, show me the directive. Which is the directive?
Yes, Madam, sure. It's the directive.
Yes.
I'm showing you.
Hmm.
Yes, Miller. 7 mil. Page
Page?
17.
Page?
Page 17.
17.
17.
Hmm.
Enrolled member of the force who have been transferred from a station upon completing either 10 years in a continuous spell or 15 years in a broken spell at that station will be eligible for posting back to that station solely on criteria of the last posting or on extreme compassionate ground which is to be scrutinized based on merit and approved by the transferring authority on case-to-case basis. They shall be given a posting in a unit post outpost out of first 3 choices shot by them as far as possible.
So
So there
this
is no
means
absolute doubt.
that you have been in Guwahati for 10 years continuously or 15 years continuously.
Yes.
And then say you are now working in Katia. You have given an option that give me in Guwahati. 3 options you have given. It is under that circumstances, this clause 7 will come into being.
Yes, madam. I'm not
If
insisting.
it is yes
I'm
to
not-
everything, what is there?
I'm not insisting that I should be posted back to Guwahati. They could have posted me as per the couple ground, my lord, considering
Couple ground they had brought you. They said that is a
Only
mistake
in the
we have
last
done.
year they have considered, my lord.
24.
24.
That they have dealt with.
It's not one time, my lord. They can consider it
No, you
again.
go and join there, then make an application, then we will see.
In nearby place, I can be posted. Rongya is there.
Where have you said Rungya? Have you said have you given any choices in your
Yes, my lord. I have given.
presentation? Where? You have not given any choice in. Mr. Rafiq?
Yeah, Lordship, can you see page 45 minutes?
45. Huh.
My simple prayer, my lord, involve the facts and
That they have
circumstances
considered.
hereafter.
They have considered dismissed. Okay. Yes, Mr. Kaushik. You are there?
Yes, ma'am.
Yes. What do you have to say?
Lordship, a second note of this clause H of page 48. Now, this 22 years is out of 28 years of service. So in 24 also he got this. Now, if your Lordship will kindly come to the clause I, my lord, that would be also.
I of that impugned order.
The impugned order. The second paragraph. The guideline provides that the efforts may be made to post both the husband and wife at one place, however, does not confer any right to the petitioner for posting at one place throughout his service.
Where are you reading?
My lord, the clause J,
Second paragraph.
Second paragraph. This ground was considered by the authority. The guideline provides that the effort may be made to post both husband and wife at one place, however, does not confer any right to the petitioner for posting at one place throughout his service. The petitioner cannot remain posted in Gauhati cluster. Posting of the petitioner and his wife should also take care of the administrative needs and claim of the other employees. His wife so-and-so, employed in so-and-so, shall be transferred and posted to his station of posting so-and-so, which has number of office units of the...
Your wife will follow you. No.
Again,
And in fact, my lord, in the last paragraph, he has also given a liberty to apply for premature transfer whenever it is open.
My lord, my submission before your lordship first is that they cannot issue the transfer order.
We got it.
30%.
We got it.
So it is wrong, my lord. So it should be set aside, and Odisha High Court has only on this ground has set aside the same case, my lord.
Every transfer is a case on its own. There cannot be a set ratio.
The ground is 30%.
The set ratio is violation of statutory rules.
That is there.
Malafide.
That is there, my lord.
Malafide and this. Yes, it is there, but it is also coupled with the fact that you have completed your tenure here in Gauhati cluster.
That's why I prayed, my lord, for nearby places so that I can look up to
That
my
is an
family.
administrative necessity they will consider. We cannot come in.
One
And
more.
you have not mentioned any place.
No, first I have opted my choices, my lord.
No.
The record is with them, my lord. I have opted choices.
Your representation does not say anything.
In my representation, I said nearby any place, my lord.
Okay, fine.
And your lordship, can you see page 20, last, my lord? Page 20, close and 36. where the number of eligible personnel opting for the same unit, post, outpost exceeds the frozen vacancies in respective ranks in the particular unit.
You are reading?
post- Page 20, Your Lordship.
20 clause?
36, 34, 86, 66, 36. In posting, it shall be given in the following descending order: suffering from a terminal illness himself, herself, being a caregiver, and number 4, my lord, spouse working. So they should consider, my lord. This ground is there. And my lord, vacancy, there are lots of vacancy in Rongia.
Lekha, as agreed to by the learned counsel for the parties, the matter was taken up for final consideration at the motion stage itself.
So may I just point out one thing with regard to that ground that it has to be done within 31st March, that was approved by the authority and it was extended to 30th June.
It cannot, my lord. Even in administrative exigencies, my lord, only 2 months can be extended. It is clear, my lord.
And that extension order is not under challenge.
It's on record?
No. I've got the instruction as per your lordships.
Also.
This is the approval.
Hearing concluded, registry to list this matter again tomorrow. Kali dinner for delivery of votes. I'll go through it once, then pass it.
Grateful.
Correction. I'll just modify the earlier order to make it a bit more sensible. But the essence would be that.
Well, here I have an instruction not to praise the better man. I have an instruction not to praise, my lord.
Rightly so.
Yes, my lord.
You have suppressed things here.
No, my lord.
Mr. N.J. Khatonia, learned counsel for the petitioner, on instruction submit that the petitioner desires, now you have become a professor.
Yes, yes, both of them, my lord, both of them.
Desires not to press the writ petition any further. Accordingly, he prays that he be permitted to withdraw the present writ petition. Mr.
N. Bormon.
N.
N. Bormon.
N. Bormon, Miss Madam Bora, and Mr. N. Bora, Miss Bora, learned standing counsel, health and family welfare department, and Mr. N. Bormon, learned counsel, appearing for the respondent number 5. Submits that they have no objection to the prayer made by the learned counsel, does not object to the prayer made by the learned counsel for the petitioner. In view of the above submissions of the learned counsel for the petitioner, the present petition stands dismissed on withdrawal.
Oblige.
Oblige, madam.
None appears for the petitioner, even on second call. So accordingly, the present writ petition stands dismissed for non-prosecution. Yes, Mr. Bodle. What is this happening?
Lordship, there were 2 persons.
We are not concerned with 2 persons, 3 persons. This man, admittedly, you have recognized his working.
He rendered service, Your Lordship.
He rendered service. He was there. He is covered. You have, if he is made a junior inspector, that means he was a secretary provincialized. That is why you brought him to a junior inspector. Now, why are you denying to him the benefits?
Because the 1994 provincialization list, Your Lordship, his name has not.
Let us see that list. It's on record.
Yes, Your Lordship.
Page?
It's page number 6 of my affidavit in opposition.
This letter only gives them that period from 94 to from 94
20 to 994 onwards, Your Lordship.
That period only, but this is not the provincialization order. You have been saying it's the provincialization order all along, but this is not the provincialization order.
Lordship. Otherwise, the serial number 136 Abdul Hamid.
That is a different man
Lordship.
altogether because his recruitment is of 79.
Yes.
Whereas this man is of, I think, 70.
70.
But you see, this order of 2006 that you have passed
Lordship.
is also come to page 12,
Lordship.
right? This you have not denied. If this is not denied merely because his name was not incorporated herein, cannot be.
That is true. That is true. Lordship may dispose of the matter by directing to complete the process within the time frame. Lordship.
We will hold that he is entitled. You want an adjournment. You are appearing for?
A Paramanik Lord.
Where is he?
Lordship, he is there, Lordship, but the record is with H. Talukdar, Lordship. And he is appointed as PP and he is at another district, Lordship. That's why
So you don't want the matter to be allowed. Okay,
Lordship,
we'll adjourn it.
there, Lordship.
Huh?
Because we don't have the copy, Lordship.
When can you get your brief?
After 2 weeks, Lordship.
Lordship.
I wanted to allow this petition today. Can't help it. The learned counsel for the petitioner. A prayer is made on behalf of the petitioner for an adjournment in the matter on the ground that the brief of the petition, brief is with Mr. H. Talukdar, who is no longer practicing before this court on his appointment as a
PP, Lordship.
public prosecutor, state public prosecutor. Also, prayer is not objected to by the learned counsel for the learned standing counsel corporation department. Also, accordingly, registry to list this matter again on 6/8/2026 as a top of the list item.
Obliged, Lordship.
You lost your chance today. Oh, I'll do leftover night. Oh, it was a belik tonight.
Similar matter has been fixed on 20. Other than Lordship. Series of matter has been. I have been told by learned additional agent.
This is that.
Yes, my lord.
Because
Can
I
do, can do. Yes, my lord.
29. As
29.
agreed to by the, we have fixed those matters on 29. Because there is another matter pending before the
Division
bench
bench.
on 23rd. We have fixed these matters on 29.
Obliged.
As prayed for by the learned counsel for the parties, registry to list this matter again on
Obliged.
29th to board edition, 37, 2026.
37.
Same thing will cover.
Obliged.
I'm appealing for item number 27, my lord.
Yes, Mr. Chaudhary.
My lord, matter is relating to the, my lord, pensionary benefit to the workers employee, my lord. And my.
Mr. Chaudhary.
Yes, my
we
lord.
have placed all the similar matters on 29 and 30.
Lordship fixed on 29 because from 31 I am not available.
31, not 31, 30. 29, many matters have been.
My lord, on the 29.
Oh, Mr. Chaudhary says we.
Yes, my lord.
Same, 29 will be.
26 also, my lord. Same.
29 will be. Huh?
Obliged.
Yes, what is your prayer?
Lordship, my salary is stopped, my lord, since 2011, my lord. And,
You are working as on date?
Yes, my lord. I'm working.
They have filed an affidavit. What is the stand?
And I am also entitled to minimum pay scale, my lord.
Huh?
I am entitled.
That
to
Upendas is gone now. Upendas is gone. What is the stand?
End of the department is, my lord, I am working, my lord, and due to, my lord, not sanctioned for releasing the salary, my lord, the approval of the finance department is required, my lord.
Yes, what is the stand of the finance department? Who is appearing for the finance department? Mr. Nayak.
Yes, sir. Regularize.
Yes, Mr. Nayak.
Minimum pay scale, Lord, sir.
Jagjit Singh. Why is he not entitled to the minimum pay scale?
The finance has rejected the proposal.
Why? We have Jagjit Singh. Forget Upendas now.
Yes, Jagjit Singh is there. Another two judgments were earlier also there were judgments, Lord.
Forget it. Jagjit Singh is the commonly followed one. So why will he not be entitled to at least the minimum? Regularization is out of the way. He says he is working.
And Lordship will take up this matter, Lordship. Or let me just now I have become aware, Lordship, one such matter is there.
On the prayer of Mr. P. Nayak, Learned Additional Advocate General appearing for the state respondents, the registry to list this matter again on 4/8/2026. 4/8. Only on that, Mr.
Yes, Lordship. Lordship has fixed item number 26 on another date, I think.
26? Yes.
That regularization matter, I think.
On 29.
29.
All matters on 29.
Lordship. One matter is pending before a division bench, Lordship. It is coming on 23rd.
That's why I put it on 29. That day you told me. So we have put it on 29.
Okay,
My lord, will kindly see the impugned order. Two orders, my lord. Page 67.
Page
67. Then I'll place, my lord. May I read it, my lord? In this regard, regarding payment of pension area, legal notice and so in this regard, it is intimated GID 6 below Rule 10A, CCS commutation of pension rules. And as per the Government of India, circular number so and so, 2008, those who commuted 100% pension continue to remain non-pensioners till their pension is restored. In Welfare Association case Supra, persons who commute the full pension and who will not be given the monthly pension by deeming monthly pension to have been reduced to nil has been treated as a separate category. Since Sri Satyabroto Das commuted 100% pension at 735, therefore, as per the above mentioned,
after this, what happened?
After that, my lord, after that, I have put this teacher, I read a legal notice and the page 68 was another order, my lord. It's almost same thing. Page
That's a reply to your
reply to. Now, my lord will kindly see that I retired in the year 1994. My lord, I retired in the year 1994.
1994 from where?
I just tell you. 27/10/1994, I retired. And I joined on 28/10/1994 in Assam University on deemed resignation. 28/10/1994, I joined the Assam University. Then soon thereafter, in February 1995, I applied for 100% pension. Then, my lord, what happened? Since this was not granted, I approached this honorable court. And after notice being served, my lord, they granted my pension on 17/6/1998.
Page?
Oh, my lord will kindly see. Copy আছে there. My lord, page 28. This an amount of rupees 1,24,362 was paid at the rate of 734 per month, pension per month. And this was paid on in the year 1998. Now, in the meantime, the pay revision, the pension was pay revision took place in 1196. Thereafter, my lord will kindly see.
But you are not there, or the revision benefit for pension.
For pension, when in fact, what happened, the lordship will have a look at page. I'll just take your lordship the relevant page. You have to that. No, yes, my lord will kindly come to page 40. 40.
This is for your BSF thing.
BSF. Page 40. Lordship, I read it. Referring to subject certain, I am to inform you that Shatyabrata has joined the Assam University on permanent absorption basis on 28 October 94. He was released from BSF 27th October 94 after completion of 20 years of service after rendering the technical resignation. The BSF authority has accepted his technical resignation on 25/195. As per pension rule 1972, the pensioner was paid lump sum payment of rupees 1,24,000 from on 9/6/98 in lieu of pro rata pension, monthly pension, but Ministry of Home Affairs granted 100% pension.
So after that, you have been now given a fresh PPO, 5,000 monthly pension has also been allowed.
Now, my lord, kindly come to page 42. That was the page 42, 42. But in fact, what happened? The pension was fixed like this. My lord, on 94, my pension was 735, which they have given. And up to 31/12/95, it was 735 before coming into effect of the revision. And 1/1/96, it was 2241. And the date when the pension was commutation was given, my pension was 2241. So, my lord, my commutation ought to have been given at the rate of 2241 instead of 735. This is my claim, 735. And after 15 years, it was restored, my lord. This is my case. Now, they say, since for the 15 years, I took 100%, so I am a non-pensioner. But it is prior to that, it is fixation of pension. Now, my lord, either they have two options, my lord. I'm not saying they have two options. One is, if you calculate my commutation from 1994 at the rate of 735, my 15 years comes to an end on 2009. So, up to 2009, you can give is to 734. After that, it should be 2241 or even it was higher than 229. That's right. So, or you should give me the fix my pension at 2241 commutation, and the balance amount should be given. 735 I have got it.
Yes. Mr. Gupta.
Lord, so far as the pro rata pension is concerned, my lord, that was already he excised that option for commutation.
No, what was the basis for that? What was the base amount taken? 735 or 2?
That was a commuted amount, commuted pension. My lord.
That is 100% commutation.
100% becomes after 15 years. That is as per Rule 10A.
100%.
As per the commutation of pension rules. Rule 10A. The commuted amount of pension shall be received. Yes, my lord. Page 19.
The committed amount of pension shall be restored on completion of 15 years from the date of reduction of pension on account of commutation becomes operative in accordance with Rule 6. Provided that when the communication amount was paid on more than one occasion on account of upward revision of pension, the respective committed amount of pension shall be restored on completion of 15 years from the respective date. So, my lord, when he opted for commutation, the amount he was entitled was 735. And thereafter, after 15 years, my lord, full amount of pension has been given to the petitioner. And my lord, the petitioner was also granted the arrear pension from 9/6/98 to 8/6/2013.
Okay.
And so far as the claim of revision is concerned,
But the learned counsel for the parties at some link registered to list this matter again on 24/7/2026 for
Well,
further hearing.
24, I may not be here, my lord, lordship, out before or after? Huh? 23, 24 and 25, I will not be here.
28.
28. Hmm?
28.
28.
28.
28. Obliged, lord.
Let me just.
Lord.
apply my-
Lord.
Lordship, the present writ petition relates to protection of pay. Now, he is actually claiming this pay protection benefit on the basis of one OM issued by the DOPT. Now, if I may take your
Is
lordship,
there an urgency in this matter?
lordship, this matter is otherwise pending for a long time.
25?
25, your lordship.
We'll have it because we are having some old matters to be disposed of today. So I'll not take up much thing. As agreed to by the learned counsel for the parties, registered to list this matter again on 6/8/2026.
6/8.
Actually, the earlier round of writ petition was disposed of,
I know.
then again, I.
6/8, na?
Yes, madam. What is it? Oh, that.
This is
PF.
regarding that RPF transfer and posting. So to understand it in a better way, the chronological in a chronological manner, that annexure 2, the letter dated 12/7/23. So this is the main letter.
What is your grievance basically?
So here, your lordship will see, we will find that all the petitioners who has actually applied back in in accordance with the letter dated 6/9/23, their letter was not at all been considered. Whereas the standing order is very clear that when there has to be some transfer and posting, the ratio should be 50/50. But here in this,
50/50 means?
the ratio should be equal between the RPSF and the RPF.
Oh, that.
Yes. But here, what we have seen is the RPF member is only 24% and rest, the 74% is the RPSF. So now, your lordship may just see annexure 3. This is the directive 60. So directive 60 says the RPF.
Where is the 16/4/25?
This is the annexure 1. This inter-railway transfer of RPF/RPSF personnel on request ground.
So You want this court to interfere with this order.
Yes,
So all the transfers that have been now ordered in this case
yes,
will be nullified.
nullified.
Where are those persons who have been, who will be affected? Have you made them party respondent?
Yes, yes. Some of the petitioner that
Where are the
21
other-
petitioners.
21 petitioners are the persons who are seeking to nullify that 16. Now, when I nullify this, I'll be interfering with the transfers affected in respect of the others.
Yes.
Are they party respondents?
They are not been made respondents into this,
Then-
but with this notification, the petitioners have been affected for a
Let us-
for a
let
reason.
them understand one thing. Today, if I interfere with, I accept your prayer, I'll have to interfere with 16.4. If I interfere with 16.4, that means these people who have transferred out will have to be brought back.
Yes.
That they'll have a prejudice to them. How can I pass the order without hearing them?
Now in that regard, your lordship may just see page, the directive 60 first, which is at page 64. It says, Directive 60 on the subject of transfer of the members of force from RPSF to RPF. So the RPSF, if they want to take the benefit of the transfer, they has to get themselves converted from the RPSF to RPF first. Then only this Directive 60 will come into play. Then thereafter, because Directive 60 is very clear, I will read some of the points. That page 65, para 2. It says RPSF is a specially trained unit within RPF to be raised as a reserve force on the battalion pattern. The force is mobile and is called upon to assist RPF and other railway security agencies in case of deteriorating security scenario like large-scale civil strife, extensive damage and destruction of the railway property, prolonged obstruction of trains due to law and order and disturbance among the others. This is actually the definition of the RPSF. What is the role of RPSF to play? Then page 66, guidelines for transfer from RPSF to RPF or vice versa. So these are all guidelines. Then your lordship will see page 72, that Directive 58 revised. Directive 58 revised is only particular to the RPF personals. Then there comes page 76, the periodical transfer of the enrolled member of the force, the para number 5, 6, and 7. More importantly, 5 and 6. It says, if I may read, para 5.5, cases of transfer of RPF staff who have completed 10 years at a stretch of 15 years in a broken spells in a station shall be considered during periodical transfer. That is, such staff shall be transferred out of the cities, towns where they have spent 10 years at a stretch of 15 years in broken spells. However, such RPF personnel who are on verge of retirement, who are left with not more than 9 months of service, may be exempted from periodical transfer if they wish to continue at the same place of posting. While counting 10 years at a stretch of 15 years in a broken spells, deputation period spent at that station shall also be counted in case of non-gazetted RPF personnel. However, in instances where a significant number of enrolled members of the force have completed either a continuous tenure of 10 years or a cumulative tenure of 15 years in a broken spells at a specific station, and where it is not feasible to transfer all of them simultaneously due to scarcity of adequate replacement, the enrolled member of the force with the longest duration of service, senior most in station seniority, shall be transferred out of the station to the extent of replacement available from other station. Page 77, then para 8. No enrolled member of the force shall be posted back or attached to the same post, outpost, for at least 10 years. 12 years for inspector. The period of 10 years shall be counted from the date of his relieving from the unit, post, outpost. Then 12. Transfer in Northeast Frontier Railway NFR for the purpose of tenure transfer within the NFR. The whole NFR will be treated as a non-hard area, notwithstanding anything contained in the list of the hard area. So these are some of the points. Then comes
you are all working in the NFR for the last around
more than, now it is about to be 20 years.
20
Near-
years. But
nearby
you-
20
you-
years.
You have not been favored with an
No.
out of the state.
Yes, and this is the all over India list. And now your lordship will see again page number 91. So this is the directive 58 revised what we have read, and now this is directive 58 which has now been modified.
You
It
all
says-
all are constables.
Yes. So now this is the existing provision. It says the directly recruited sub-inspector and constable shall be eligible for interzonal transfer on completion of 10 years of service, including 10-year training period. This is the existing provision. Now which is modified as the directly recruited sub-inspector and constable shall be eligible for interzonal transfer on completion of 8 years of service, including training period, which has now been reduced to 8 years. So then comes again another letter 5223, which is annexure 6. Here is also another list which was published before in the year 2024. Here also the RPF personals who were selected and who have been considered is only 142 members, whereas the RPSF has 891 members. Now your lordship may just see page 120, annexure 7. Annexure 7, this is the standing order. And the relevant portion your lordship will find at page 124. This para B. 80% of all vacancies for a particular zone shall be filled up in accordance with the seniority of application for that particular zone to be established after combining the request application received from all zones. For filling up these vacancies, RPF personnel shall be preferred for the first 50% of the vacancies of a particular zone. However, if the number of willing RPSF personnel exceed 50% of the vacancies, the remaining 50% of the vacancies shall be filled up by the willing RPF personnel from zonal railways. So there has to be an equal ratio. So then your lordship will again will see annexure 8. Annexure 8 is another window which was open in the same year, back when this 12/7/23 window was open. So this is another window which was open, and for which all the list at page number 130, this is all the list of the RPF who has applied, who has exceeded that 15 years of service here in the particular area. They have applied. They were never been considered.
Yes.
Already filed my detailed affidavit, lordship, but prior to that, lordship had already pointed out those persons who were not made parties, and most of lordship, all those orders were passed in few of boards, railway boards later dated 12/7/23. But that order is not under challenge. The base of all these orders, subsequent which has been shown,
Which is the order?
12/7/23. Lordship, this annexure 8 also, all the orders. That is on the basis of that boards
12/7.
later.
Where is that 12/7?
This is annexure 2.
Oh, that.
Yes, yes.
Annexure 2 is 16/4, but that is in view. Annexure, yes, annexure, but that is not under challenge, lordship. That
Where is
12/7.
that letter? Just show me that. Annexure 2. That is directive 60.
That is another one. Railway board later dated 12/7/23 is annexed as annexure A to my affidavit.
Annexure 62, it is a window when the window was open. The first window.
Annexure A, page 180. This is the letter, that letter is
That
not
is
under
page
challenge.
62. Okay, fine.
Page 62, it is the window when the date of start of window for inviting application.
Yes.
So so there, that
when it has to applied, when has, those things are there, Lordship, but those were not followed by the petitioners. And that date of start of window and all these 16/4/2025 and subsequent orders on the basis of these orders, Lordship.
So they did not apply.
12/7/23 order is not under challenge.
No, challenge, forget it. Did they apply?
They probably applied later on, Lordship. So all they have challenged this order, but this 12/7/23 order is not under
So
challenge.
what is there to be challenged?
So
Nothing
this is where the guidelines are there, Lordship, when to start the windows inviting
This is
applications.
nothing.
This
It
is
is 58, which is to be followed. 58, then your subsequent modification says that RPF, 80% of the vacancies, 50 will go first to the RPSF because they are in a forward moving force. And the remaining 50% will be by the RPF. Now, her contention is that the 50%, you have not done it. You have exceeded 50% of RPSF and you have ignored the cases of not only the petitioners, but other constables of the RPF. That's the case.
Lordship. And that ground we have stated in paragraph 3, paragraph 5, that Directive 58 is applicable for RPF personnel to RPF. For those RPF personnel across India is governed by Directive 58 revised, whereas transfer of RPSF personnel to RPF is covered under Directive 60, which came in vogue on 29/3/2023. And here we have stated that 3 categories are there. Category 1 is from RP applications which we have received, Lordship. In each category is given.
Directive 60 is of, okay, where is Directive 60 otherwise? Where do I get Directive 60? Is it on record?
Yes, it's there on the record. Directive 60.
58 is there, 60?
60 at page 64.
64. Just that.
The Directive 60 on the subject of transfer of the member of force from RPSF to RPF and vice versa.
So this is basically for RPSF to RPF.
RPF will have the benefit of getting transfer and posting, but to avail that benefit of transfer and posting, RPS has to get themselves converted into RPF first.
I know that, but 60 pertains to RPSF.
RPS.
RPSF.
RPS.
Okay.
And one more interesting thing your lordship will see. Just your lordship will have page 177 of the affidavit filed by the other side.
Just now.
Thank you.
One?
177. It's a very interesting para. The affidavit which has been filed from the other side. Para 11. 177. Serial page number. That with regard to the statement made in paragraph 10 of the writ petition of the deponent states that the transfer order dated 16/4/25 has been issued as per provision contained in Directive 58 revised and Directive 60. As currently these directives are in vogue. Standing Order 102 mentioned by the petitioner has been withdrawn on 17/9/14. Your lordship will just note this date. And replaced by Directive 32 dated 18/9/14, which also stood repealed on 1/1/20. Hence, when the concerned standing order is not in vogue, then the question of its violation does not arise. The petitioners, while alluding to standing order 102, are constantly making an incorrect, misleading, and false claim before this court. Now they say that standing order 102 has been withdrawn on 17/9/14. So now your lordship will see page 234 of my affidavit in reply. Page 234. So this is the railway board letter, and here at Roman 10, at page 235, if your lordship has found, page 235, Roman 10 says transfer of RPF and RPSF.
That is not covering. Somebody has just put it there that 2015 notification is not for RPF. It is for the general officers. Okay, now, okay, I accept your prayer. I'm interfering.
Yes.
How can I interfere? Just tell me that.
The interfering in such a manner, we are not questioning the transfer of the other persons, but at the same time, they have not maintained the equal ratio. Further, they says that NFR is not no more a hard posting.
Okay, now when is the next window opening?
We don't know. And they have again opened up a window for RPSF, the recent development.
That instruction I don't have.
Get that instruction. Because they have a grievance that you have not applied. You have given emphasis on Directive 60 while not emphasizing on 58. 58 governs them also.
Lordship, but reasons we have stated in paragraph 5,
Reasons
Lordship,
are-
that their duties are more.
Maybe, but you can't go against your own circular. Says 50-50. Maybe onerous, but it is 50-50, you say. You get your instructions as to how you can protect their interest, because they have completed more than 15 years now in Northeastern region. They are entitled to their choice. Place of
More
posting.
and more importantly, your lordship will also find there we have annexed the RPF manual. Manual says that NFR should be treated as a hard area zone. So now it has been revised in 58 that it is now nil.
Non-hard area.
A non-hard area.
If it was a hard area, you would have got a certain benefit.
Yes.
So, Lordship, this window is open after 9 years for RPSF. But for them, it's a general.
No,
they,
You get your instructions as to how they can be, their grievance can be redressed. Otherwise, we'll ask her to implead those persons and then we'll have to go ahead and cancel all those things. We don't want to disturb the whole position. You get your instructions.
Lordship.
And more importantly, your lordship will again, there are two more important aspects into this. That rule 99.2 says that persons who has already now been transferred. Now, even on the basis of this writ petition, if my candidature will be considered, so my seniority will be the bottom seniority.
Why?
It says in the rules.
Alright, that if that is considered in the normal parlance, if you make a request and then a consideration is made, then you will have to have bottom seniority. But if they do it in the normal course, public interest, then you're not defective.
This is not a public interest. This is they have asked all this application on request, not in public interest. Then
Don't go into
then another aspect is your lordship will see. This candidates whose application has now been considered. In the initial stage of their joining and their appointment, they have already enjoyed.
You can't have grievance with them because they are not party respondents.
Yes, they are
not
they
hear
have,
anything.
No, just for an example.
Why just have that discussion? But Miss S. Swati S.B. Burwa, a learned counsel for the petitioner. Also have Miss B. Sharma, learned standing counsel, a learned CGC appearing for the respondents. Ms. Sharma submits that she would receive instructions as to the grievance of the petitioners for a posting out, interjournal posting. Interjournal posting, na?
Yes.
Interjournal posting. On the ground that they have already completed more than 15 years.
Yes, more
than 15 years of service in NFR, in under Northeast Frontier Railways. So, how much time do you want?
2 weeks.
Give me a date. Oh, fifth, 5.
August.
7 or 10?
7.
7.
7. Register to list this accordingly to facilitate Ms. B. Sharma to complete her instructions. Register to list this matter again on 7/8/2010. Let's to 2026. Let's see how they do it.
Lordship.
If
In
they
between,
come up with
Lordship,
a policy
Yes.
which will redress your grievances, then I think that is the end of the matter.
in between, Lordship, 1200 RPF personnel have been transferred in, but these person RPSF, their window open only after 9 years.
You cannot. You cannot. Your circular speaks of something else.
Lordship.
Okay.
How like?
Mr. Das, what are you waiting for?
School transfer, whatever. That is in violation of Rule 5. Similar cases will disposed of, setting aside the thing.
No, I
giving
just
liberty.
wanted, because that day they could not give me any instruction.
I'll just give 2 judgments of this court.
But I'm otherwise ready with the matter. Yes, you have got your
Yes.
instructions.
Lordship, I have got my verbal instruction.
Ah.
The district, state level committee's recommendation was not taken.
Not there. Item number, Kiman?
38. Just to set aside giving liberty
That's
if
all.
they deem fit proper.
That's all.
2 judgments, I'm just pressing my lord.
No, that day, Mr. Sharma,
It has to go in that manner. Impugn order has not followed the mandate of the.
you are still continuing in the
Yes.
earlier school?
Yes.
Mr. Council, you be here, the second half. You need not be. We'll record your name. We are allowing the petition.
May please, your lordship.
P5.
The impugn order, your lordship will find, impugn order, your lordship will find at page 34. That the petitioner was terminated, the petitioner was in probation, he was terminated on the ground of misconduct, lordship, without conducting any disciplinary proceeding. And that is also an admitted fact in their affidavit in opposition.
Termination order?
Page 34, lordship.
3/4.
3/4. 18/11/2025.
Where is the show cause?
Lordship, at page number 30, by letter dated 4/10/2025, they.
This is the show cause.
Yes, lordship. They asked me to furnish the written
Any
explanation.
written statement, any affidavit filed by them?
Yes, lordship. They say that there was no expertise person to conduct the DP in the department, so they could not conduct it. Page number 38, 39, and 40 are relevant. Para number 10 and 11, 10, 11, and 12. Okay. Page number 40, your lordship, may kindly see. May I read, lordship?
Yes, madam.
Lordship, on the last occasion, we were directed to produce the records.
Forget the records. You have not
Lordship,
produced the
we're-
records, forget it.
We're actually waiting.
Justify the order. Justify the order.
Lordship, then let my senior come. He's on legs in court 1.
He's coming. We'll pass the orders to it.
Lordship.
Second up.
Lordship. Orders.
Wait, please, Your Lordship. Right, order dated 9/2/2024, page 110, Your Lordship. I was compulsory retired.
Okay, compulsory time. Pleading complete.
Please complete, Your Lordship.
That is stated that the pleadings in the matter is complete and the matter can be taken up for final disposal. For final hearing, for final hearing. So accordingly, as agreed to by the learned counsel for the parties, the registry to list this matter again on 11/8/2026.
Very good.
Interim
order.
Interim order passed earlier to continue till.
Very good, Your Lordship.
Shorted may be given, Lordship, because due to the interim order, he is continuing.
Okay, on 08/2026.
Very grateful, Your Lordship.
In item 37, my affidavit is, I have already drafted the affidavit. It will be filed.
On the prayer.
One time is required.
Learned Standing counsel
Lordship, a date may be fixed, Lordship.
AG.
APGCL.
APGCL. Comma, the matter stands adjourned today. Registry to list this matter again. When are you filing the affidavit?
I need 1 week time, my lord.
Lordship, date may be fixed, Lordship.
Registry to list this matter again on 3/8/2026. The respondent shall invariably bring on record their affidavit by stand by way of filing an affidavit on or before 24/7/2026. The petitioner is at liberty thereafter to file and the petitioner is at liberty thereafter to file a rejoinder thereto, comma, if so advised. Tar pisot he registry to list this matter again on 3/8/2026.
Not. All right.
Second up. Oh, he took from my Facebook. Second up, what call you order? Yes.
Yes, Lordship.
49.
49.
Bill, there is nobody there. Second up.
Lordship.
Yes.
Lordship, the file is under process.
You were missing for a long time. We were thinking of asking the registry to lodge an FIR.
My lords.
What happened?
This is under process, my lords.
What process?
The AG has
When did
raised.
your father die?
My father died in the year, and after the death of my father, my
Mother was getting, mother died
mother died in 2017.
17. And what are you doing from 2017 onwards?
My lord, that rule came in 2018.
From 18, what is that?
My lord, then she applies, my lord, in the year.
24.
She applies in 24.
What is this? I don't understand this.
My lord, the district has forwarded, my lords, all papers. Now, my lord, the EC is under process. My lord, the office of the AG, Accountant General, has raised some queries, my lord. That is, it's under scrutiny, my lords.
When did you forward the papers to the AG?
Papers were forwarded to my lords, to the, not the AG. HPS 57, my lord, the DFO forwards in 9/9/24.
Page?
57 on the petition, my lords.
So what are the queries asked for now?
And then, my lords, the PCCA forwards it to the government in 22/9/24.
Then?
Then, my lords, the process was going on, but
No, when did it go to the AG?
My lords,
When did it go to the AG?
that knowledge I don't have, my lords, but it is under process. My lord, I think one thing I have to admit, my lord, it was gathering, it was in cold storage for a few months. After we stepped in, my lords, then it is again under process. So it is under, we are being for now, you're vigorously following it. My
No,
lords.
what is the big thing to be done here? What is the massive exercise required to be done? Nothing.
Not too much,
Only
my lord.
whether she is employed,
My lords,
whether she is unmarried.
my lords.
These are the two things you got to ascertain. After ascertaining whether she is the
My
daughter
lords, agreed,
of
my lord,
that.
agreed.
Three aspects only.
Agreed to it, my lords. But what had happened, my lord, as I admit, my lords, it was gathering cold, it was in a cold storage, my lords. Only now
When
it is.
can you send it to the AG?
My lord will post this matter after 10 days, my lords. It can be
Mr.
done,
D.
my lords.
Gogoi. Wait, we'll get it done. Mr. D. Gogoi, learn Standing Council, Forest and Environment Department on instruction submit that the processing of the matter for forwarding of the proposal for grant of family pension to the petitioner being the unmarried daughter unmarried daughter of the deceased government employee is presently at an advanced stage, and he submits that within a short with advanced stage, and the same would be submitted before the submitted to the office of the accountant general shortly. Accordingly, he prays that the matter be taken up on (28/7/2026), on which date he shall apprise this court about the developments taking place in the matter. Also, registered to list this matter again on 28/7/2026, reflecting the name of Mr. D. Gogoi, Standing Council, Forest Department.
Obliged.
Yeah, please, Lordship. Lordship, affidavit is ready, Lordship. Otherwise, some clarification is required, Lordship. 1 week time will be granted, Lordship. As it is ready, Lordship.
They are doing the same work like police drivers, but you're not, they are more dangerous situation.
We work 24 hours a day.
24 hours, anytime they are called. Why the parity is not? Yes, Mr. Cholia, but why?
Here we have, Lordship, here the 8th pay commission has been constituted.
Forget the 8th pay commission. But here they apparently, it seems that your high HMV. What is that? Heavy motor vehicles.
Heavy motor vehicles.
They are 24/7 in the job.
Yes,
They are doing more onerous duties and their responsibilities are much higher. They are also required to look into this disaster management
Lordship,
thing.
that is not.
Somebody falling in a ditch, somebody falling in a well, is they, not the police who comes.
Lordship, yes.
In fact, my lord, though we were appointed as a driver, we discharged 3 functions. Even as an operator
of that
thing. Yes. For that, we are not being paid.
1 week, Lordship.
Yes, Lordship. We have also received, Lordship, there is some distinction that has been drawn from the post from the ROP rules, Lordship. We'll like to bring it on record. 1 week time may be granted, Lordship.
Mr. A. Chakraborty, learned government advocate, and Mr. S.C. A. Cholia, learned Standing Council, Finance Department, appearing for their respective respondents, praise that they be granted time till. Take your time,
Yes,
as much you want, and then, but no date further.
Lordship, yes. The 15th, Lordship, after.
Till 17/8/2026 to bring on record their to file affidavits on behalf of the respondents represented by them. So it is assured that the affidavit would be filed on or before the next date of listing, on or before 17/8/2026. The petitioner is granted further. Thereafter, the petitioner is granted, the petitioner is granted time till 28/8/2026 to bring on record rejoinder to the affidavits filed by the respondents, if so advised. Registry to list this matter again on 8/9/2026. These are people who are there for the work society,
Lordship, yes,
we should not keep them waiting.
Regarding
We'll have to
the
take up and
duties, Lordship, that is not.
on 8-9 we'll.
Well, great.
Published.
The petitioner before lordship are home guards, my lord. And my lord, they have been terminated from service, my lord, without following due process. And my lord, our contention is that, my lord, the termination is punitive in nature.
So we'll consider this. So there are
My
some
lord.
matters which I'll have to pass some orders today. May not be in a
My lord.
position to do.
My lord, 1811 order, my lord, will produce, my lord, 1811-2025. They are suffering, my lord. They are not been given any deployment, my lord. 1811-25.
Page, the order sheet.
Order dated 1811-25. Pursuant to allegation that, my lord, no principles of natural justice were followed, my lord, a submission was made by the government council that some proceedings are going on against the petitioners. To that, my lord, the honorable court has directed, my lord, to submit the report. Now, till date, my lord, that report has not come.
Yes,
Today is
Mr.
July,
Chakraborty, where is the report?
At two kindly fix the matter at two lordship, is Sutia is handle the case lordship.
Huh?
Since senior counsel T Sutia is handle the case lordship, at two lordship, at two.
2 weeks and we have orders to dictate. After that, after the orders are dictated, if time permits. we'll- Are we yes, nothing. Today, 2 we have orders to dictate, will not be in a position. As agreed to by the learned council for the parties, the registry to list this matter again on 6/7/2026. 6/8/2026. Yes, readings complete.
Yes.
Yes, Mr. Chaudhary.
Yes, my lord, we have been waiting for a long time. It's been already 2 years and repeatedly the government had taken time. Lordship will remember it's an original inhabitant issue because of which the APSC, ACS appointment was not made to the petitioner.
We'll
Now,
have to hear this matter.
my lord, on the last occasion, Lordship has stated that attempt will be made to dispose of the matter. But as I have heard, Lordship will be busy today after.
I'm passing orders, the 3-4 orders are there.
I understand, my lord.
That if time permits, we can take it up.
Yes, my lord. I'll wait. So much.
None appears for the petition on call. For the ends of justice, registry to list this matter again after 2 weeks on a date to be fixed by. এটা কি order people are actually move without TDS.
Lordship, I was here, your lordship, item number 40, your lordship. But for just for a second, I was outside, your lordship. Fix it on 6/8. We have urgency in the matter. If your lordship can fix it on earlier, your lordship, either on 23rd or 28th, your lordship. 23rd will be more.
28.
Close.
28. Done.
Deeply applied.
Very bad.
My lord, item number 23, my lord. I'm just being informed that the state government, government has made a mention in the morning. They've got some difficulty today. Gogo is.
You said?
Item 23, lord.
23, huh? Oh, Mr. Gogoi.
Yes.
Prayed for some accommodation in the east.
My lord, may I
When
pray
did I
that-
fix it?
It is on 21st, my lord.
When did I fix it?
Today, no. No,
One
not yet
item.
fixed.
Oh, one item.
No.
Oh, he said he'll come.
That there is some difficulties today.
Some difficulty?
Lordship, for other case list here.
When do you want it?
21st, my lord.
21st of November, 24. A prayer is made on behalf of on behalf of Mr. K. Gogoi, learned Standing Counsel, Higher Education Department, for an accommodation in the matter on account of personal inconvenience. Mr. R. Chakraborty expresses an urgency in the matter. So accordingly, registered to list this matter again on 24/7/2026 for admissions. So Mr. Hedas, learned counsel for the respondent number 4 is present. Four is present.
Much obliged. Further hearing.
Further hearing, you said.
All right, that's what we say.
Thank you.
Item number 3.
With effect from that date. Heard Mr. M. Khan, learned counsel for the petition. Also heard Mr. S. Das, learned standing counsel. Higher Education Department, appearing for the respondent number 1 and 3. Also heard Mr. P. Cholia, A. Cholia, learned standing counsel, Finance Department, for the respondent number 2, and Mr. H. Roman, learned counsel, appearing for the respondent number 4. The petitioner in the present writ petition has inter alia prayed for a direction upon the respondent authorities to authorize to him his pay in the his pay and allowances in the UGC scale of pay mandated for the post of prescribed for the post of assistant professor with effect from the date he had acquired his PhD degree, that is with effect from 2/7/2024. Also, as projected in the writ petition, the petitioner was initially appointed as a lecturer in Persian in the in Persian language in Lala Rural College on 18/8/1999 against a non-sanctioned post by the governing body of the said school. Also, the governing body had subsequently, in the year 2001, regularized the services of the petitioner against the said non-sanctioned post. And had authorized to the petitioner a lump sum amount as is paid for the services rendered by him in the college. Also, in terms of a policy decision arrived at by the respondent authorities for accommodating the services of lecturers, assistant professors appointed against a non-sanctioned post, against sanctioned vacant posts available in a college, the petitioner was wide order dated 25/4/2018, issued by the Director of Higher Education, Assam, regularized against a vacant sanctioned post in Lala Rural College with immediate effect. So, amongst the conditions as set out in the said order dated 25/4/2018, it was required that the petitioner, it was stipulated that the petitioner was to was to acquire his net/SLET/PhD qualification within 2 years from the date of the order, failing which his services would be discontinued. It was further stipulated that till he had acquired the said qualifications, either of the said qualifications, he would be paid his remuneration on a fixed basic pay of rupees 21,600. The said basic remuneration of the pay, however, was being revised from time to time. So, in view of in view of the prescription as made in the order dated 25/4/2018, the petitioner elected to pursue a PhD degree PhD program from Cotton University. It was Cotton University.
Yes, okay.
Cotton University. Accordingly, he approached the authorities of Lala Rural College for grant of requisite permission for pursuing the said course. However, the authorities of the said college rejected the claim of the petitioner. So, being aggrieved, the petitioner approached the Director of Higher Education Assam seeking a NOC, no objection certificate apostolic for pursuing his PhD program. So, the Director Higher Education Assam, via a communication dated 26/6/2019, required the principal of the college for taking necessary action for issuance of NOC in favor of the petitioner for pursuing his PhD degree. Accordingly, the petitioner was on 25/7/2019 issued with the requisite NOC for pursuing the pursuing his PhD course at Cotton College. Cotton College. It was Cotton College at that. At that time, it was Cotton College. Why it was Cotton University?
Cotton University loss.
Cotton University. Got it. Mr. Mojumdar, why are you here?
Yes. 40.
Mr. I have 4-5 matters to dictate. If after that there is time permitting, they'll call you.
No,
You're
but
here?
this matter also will take time.
But let us see how we can accommodate you. If not possible, because Mr. Chaudhary also made a fervent plea that he wants to hear the matter. But I had already fixed up these matters for delivery. I'll do that, and if that thereafter time permits, we will.
In the meantime, I have other matters. I'll just finish.
Oh, hey, tutta bazat ata fixes il. Mr. Sharma, we have already dictated your order. We have allowed your writ petition. Allowed the writ petition. I'm sorry. We have asked the director to pass appropriate orders within 15 days, appointing you as the principal of the college, as the principal in charge of the college. Accordingly, the petitioner got himself registered for the said course on 11/10/2019. Thereafter, on completion of the mandatory PhD coursework, the petitioner submitted his report thereon on 10/1/2000. Completed his coursework, and a coursework report was issued in his favor on 10/1/2020. So, thereafter, in terms of the procedure as mandated, a provisional registration was to be done. However, the meeting of the Research Advisory Committee was not permissible to be so convened in view of the COVID pandemic as was prevalent at the relevant point of time. So, the meeting of the Research Advisory Committee was convened only on 18/3/2021. So, the Research Advisory Committee thereafter having approved the application of the petitioner, the petitioner was permitted to provisionally register himself as a PhD research student on 9/8/2021. So, in terms of the provisional registration given to the petitioner, the petitioner was to, where is that letter?
Page 37.
Was to apply for a final registration within 2 years from the date of his provisional registration. So, accordingly, the petitioner pursued with the work involved and on successful completion of the work involved, the petitioner was granted a final registration with effect, provide a communication dated 9/12/2022 with effect from 15/2/2020. So thereafter, the petitioner completed his research work and submitted his final PhD thesis paper on 30/8/2023. So, on 27/6/2024, a notice was issued informing the petitioner that the PhD viva voce examination would be conducted in his case on 28/6/2024. The petitioner appeared before the committee constituted for conducting the viva voce examination on 28/6/2024 and thereafter, while notification dated 2/7/2024, the petitioner was the results of the petitioner was declared and he was awarded a degree PhD degree by the Cotton University. Also, the petitioner having acquired his PhD degree, he approached he submitted the relevant documents before the Director Higher Education Assam for with a prayer for removal of the stipulation as made in his order of appointment dated 25/4/2018 and also for grant to him his pay and allowances in the prescribed UGC scale of pay. Also, the Director of Secondary Education thereafter forwarded the application submitted by the petitioner to the government to the government in the higher education department seeking necessary instruction. So the government thereafter via a communication dated 30/1/2015 proceeded to regret the prayer made by the petitioner for withdrawal of the condition imposed in his appointment order, a regularization order, on the ground that the petitioner had not completed his PhD course within 2 years as mandated in the order dated 25/4/2018. The said decision of the government was communicated to the authorities of Lala Rural College by the Deputy Director of Higher Education Assam via a communication dated 19/3/2025. Also, being aggrieved, the petitioner has instituted the present writ petition. Mr. M. Khan, Learned Counsel for the petitioner, by reiterating the facts noticed herein above, has at the outset submitted that while it was permissible for a candidate to acquire the net/SLET qualification within a period of 2 years. However, a candidate opting to pursue a PhD program, a PhD course of study, was not in a position to complete the said course of study within 2 years. Mr. Khan has in this connection referred to the regulation for the degree of Doctor of Philosophy bracketed PhD issued by the Cotton University and has contended that the said program for completion of the said program, a minimum period of 3 years is mandatorily required, and the said period is permissible to be so, and a PhD program is permissible to be so acquired by a candidate within a period of 5 years, 6 years,
6 years.
6 years from the date of his registration for the said course. Mr. Khan submits that the stipulation as made in the order dated 25/4/2018 mandating acquiring of a PhD degree by the petitioner within a period of 2 years is clearly perverse in as much as it is not permissible it is not permissible to acquire such PhD degree from any recognized university within the period of 2 years. Mr. Khan further submits Mr. Khan further submits that the petitioner, having acquired his PhD degree from a recognized university by following the procedure as mandated in this connection under the regulations of the UGC holding the field, the said degree has to be reckoned by the respondent authorities and the petitioner is to be declared to have acquired all the requisite eligibility criteria for being appointed as an assistant professor in a provincialized government degree college. Mr. Khan submits that the petitioner, although in the order dated 25/4/2018, it was stipulated that in the event the petitioner does not acquire a net/SLET/PhD degree within 2 years, his services shall be discontinued, the services of the petitioner was not discontinued. Rather, he was permitted to continue with his teaching activities. Was permitted to continue to teach the students in the college in question and was also permitted to pursue his PhD degree program. Accordingly, he submits that the petitioner, having acquired the said qualification, the petitioner, at least with effect from the date of notification of his PhD degree, or a date of award of his PhD degree, would be entitled to receive his pay and allowances in the UGC scale of pay mandated for the prescribed for the post of assistant professor held by him. Mr. Khan, in support of his submissions as referred to a decision of this court, of a coordinate bench of this court in the case of Arvinda Kumar Sharma and others versus State of Assam and others, judgment and order dated 9/11/2018 in WPC number 1228/2015, and has contended that the coordinate bench of this court in the said decision had held that a period of 2 years as stipulated for the purpose of acquiring the qualification or acquiring a PhD qualification, acquiring the net/SLET/PhD qualification was insufficient, and at least a period of 5 years was required to be so granted to the candidate in question. The coordinate bench for arriving at the said conclusion, Mr. Khan submits that the coordinate bench for arriving at the said conclusion had noticed the provisions of the Assam Venture Educational Institution Provincialization of Services, Act, 2011, wherein as well as the provisions of the Assam Educational Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017, wherein the provincialized employee not having the prescribed UGC's qualification was granted a period of 5 years to acquire the said qualification. So, Mr. Khan submits that in respect of the petitioner for acquiring the PhD qualification, a period of more than 5 years was required, which was on account of the COVID pandemic, which was prevalent at the time when the petitioner had provisionally registered himself for undergoing the said PhD program with Gauhati University. Accordingly, he submits that reckoning the period lost on account of COVID-19 pandemic, the petitioner had completed his PhD program within the mandated period of within a period of 5 years, and accordingly, they said degree acquired by the petitioner is to be reckoned for the purpose of authorizing to the petitioner is due pay and allowances in the UGC scale of pay prescribed. So, Mr. S. Das, learned counsel for the respondent. Learned standing counsel, Higher Education Department. Submits that the stipulation with regard to the requirement of acquiring a net/PhD qualification in respect of the lecturers/assistant professors working in non-sanctioned post on their services being regularized against sanctioned post flows from the provisions of a office memorandum dated 17/7/2004. He submits that the said office memorandum was put to challenge before this court in the proceedings of Mizanur Rahman. Was put to challenge. Goes from so and so. Accordingly, he submits that the outer limit of 2 years as mandated for acquiring of the net/PhD qualification, being a requirement policy decision adopted by the respondent authorities, the same would mandate a strict implementation. So, Mr. Das, however, fairly submits that a coordinate bench of this court coordinate bench of this court in the case of Aurobindo Kumar Sharma, bracketed Supra, on a consideration of such stipulation made in the office memorandum dated 17/7/2004, having required the extension of the same to required the respondent authorities to extend the time period for acquiring net/PhD qualification for a period of 5 years, submits that a candidate pursuing a PhD program and acquiring the same within the extended period now coming into being in terms of the decision of this court would be permissible to be authorized his pay and allowances in the scale of pay prescribed, UGC scale of pay as prescribed for the post of assistant professor. Mr. Das submits that the petitioner, however, had not acquired the said PhD degree within the extended period of 5 years, and accordingly, the petitioner would not be entitled to receive his pay and allowances in the UGC scale of pay prescribed for the post of assistant professor. Mr. Das has submitted that the initial fixed pay authorized to the petitioner has, however, been revised from time to time, and the petitioner presently is receiving an amount of rupees 51,000. 50,000 as fixed pay for the services rendered by him as a assistant professor in the college in question. Also, I've heard the learned counsel for the parties and perused the materials available on record. In terms of the provisions of the office memorandum dated 1/7/2004, the services of the petitioner who was working against a non-sanctioned post in the college in question was regularized against a sanctioned post. However, in the order dated 25/4/2018, while regularizing the services of the petitioner, the following terms and conditions were incorporated. Page 28. So, in the present proceedings, the petitioner is aggrieved by the condition number 2 as incorporated in the said order dated 25/4/2018. A perusal of the condition number 2 as incorporated in the said order dated 25/4/2018 would go to reveal that the regularization as effected in case of the petitioner against a sanctioned post was subject to the condition that the petitioner would acquire either net/set/PhD degree within a period of 2 years from the date of issuance of the said order. The said condition also stipulates that the petition, in event the petitioner does not acquire the said qualification within a period of 2 years, his services would be discontinued, and further it was also stipulated that the petition that till the date the petitioner acquires the said qualification, he would be entitled only to a fixed pay. So, as noticed herein above, the petitioner opted to undergo a PhD degree program with the view to satisfy the requirement as stipulated in condition number 2 in the said order dated 25/4/2018, and accordingly had selected Cotton University as the institution for pursuing the PhD course by him. So, the petitioner, being now a regularized employee and being deemed to be a government servant, had approached the college authorities, of Lala Rural College seeking a NOC for pursuing his PhD degree course. The said prayer of the petitioner, however, was rejected by the college authorities, requiring the petitioner to approach the Director of Higher Education, praying for grant of an NOC for pursuing the said PhD course by him. So, on account of the intervention made in the matter by the Director of Higher Education, the petitioner, the college authority, the authorities of Lala Rural College had issued to the petitioner a no objection certificate on 25/7/2019, permitting the petitioner to pursue his PhD course. So, thereafter, the petitioner in terms of his selection for undergoing the PhD program, undertook the mandatory PhD coursework after being provisionally registered as a PhD student on 11/10/2019. The coursework, mandatory coursework having been completed by the petitioner, a report in this connection was issued to him on 10/1/2020. In terms of the regulations for grant of PhD degree as formulated by the Cotton University, the petitioner was the Research Advisory Committee was required to examine was required to grant approval for the provisional registration of the petitioner. Was required to grant a provisional registration to the petitioner for pursuing a research leading to his PhD degree. However, on account of the COVID-19 pandemic, which was prevalent at the relevant point of time, a meeting of the Research Advisory Committee was not permissible to be so convened, and such meeting was convened only on 18/3/21. The said committee had, on consideration of the case of the petitioner, granted to him the requisite approval, which had led to the petitioner's provisional registration being effected on 9/8/2021 for pursuing his research work leading to issuance of a PhD, leading to award of a PhD degree to him by the Cotton University. So, as per the said regulations of Cotton University, after being granted a provisional registration, a candidate is to pursue his research work involved, and within a period of 2 years, was required to pursue his further research, which would then lead to a final registration. The final registration in respect of the petitioner was granted on 22/12. Just mind the dates, huh? 22, just see the dates. 22/12/2022, right now?
And a final registration 9/12/2022, page 38.
Our final registration on 9/12/2022. Also, having been now granted the final registration, the petitioner had a period of 2 years to complete his research work. No, full stop. The petitioner thereafter pursued his research work, and on completion of the same, submitted his PhD thesis paper on 30/8/2023. So it is seen that the submission of the provisional submission of the PhD, completion of PhD research work and submission of this PhD thesis paper was within the maximum time limit prescribed for the same under the regulations of the Cotton University for award of PhD degree. So, thereafter, the petitioner was required to appear for a viva voce examination scheduled on 28/6/2024. The petitioner appeared before the committee constituted for conducting the viva voce and defended his research paper, which was titled Russian Studies in Barak Valley of Assam, bracket 1900 to 2000, bracket over, apostrophe over. So, thereafter, the petitioner being found to have, the petitioner having succeeded in defending his thesis paper, vide a notification dated 2/7/2024. The petitioner was declared to have qualified for the award of the degree of Doctor of Philosophy, bracketed PhD, by the Cotton University against his topic of research, apostrophe aka Persian studies, POSO. It is projected that the petitioner was thereafter conferred with the PhD degree in a convocation held in the matter by the Cotton University after the decision to, after the declaration made in his case of having qualified for award of the said degree by the Executive Council of the Cotton University. So, it is seen that the petitioner had thereafter submitted an application informing the director of higher education Assam about acquiring the PhD degree and with a prayer for removal of the and also with regard to satisfaction of the stipulation number 2 made in the order dated 25/4 2018. So the application as submitted by the petitioner was forwarded by the Director of Higher Education Assam to the government in the Higher Education Department with a request for passing necessary instruction in respect of the prayer made by the petitioner for withdrawal of the condition as imposed in his order in the order regularizing his services. So, however, it is seen that the government in the Higher Education Department via a communication dated 31/2025 proceeded to reject the prayer of the petitioner on the ground that he had not acquired his PhD degree within 2 years from the date of issuance of the said order of regularization of services, that is the order dated 25/4/2018. So, the facts noticed herein above would go to reveal that admittedly the petitioner had not acquired his net/SLET/PhD degree within a period of 2 years from the date of issuance of the order dated 25/4/2018. But it cannot be ignored that the petitioner, having elected to pursue his PhD course for the purpose of satisfying the conditions set out in condition number 2 of the order dated 25/4/2018, it was impossible on the part of the petitioner to complete the said course within the prescribed period of 2 years. The prescribed period of 2 years. However, the petitioner had completed the said course within a period had completed the said course. However, what is to be noticed is that immediately after the order dated 25/4/2018 was so issued, the petitioner had taken all requisite steps for getting himself enrolled for undergoing the PhD program and had thereafter pursued the said course strictly in accordance with the regulations for award of a PhD degree as formulated by the Cotton University and was awarded the said degree and was declared qualified for award of the said degree on 2/7/2024. The period taken by the petitioner for completing his PhD course is also found by this court to be within the time frame prescribed in this connection in the regulations formulated for award of PhD degree by the Cotton University. At this stage, this court notices that a coordinate bench of this court in the case of Aurobindo Kumar Sharma had an occasion to deal with a stipulation made in respect of similarly situated assistant professors who, on regularization of their services against sanctioned posts, were also required to acquire a net/SLET/PhD qualification within a period of 2 years from the date of issuance of such orders in their favor. The coordinate bench in the said decision, appreciating the time frame required for acquiring the said qualification and also noticing the provisions made in this connection in respect of in respect of teachers provincialized under the provisions of the Act of 2011 as well as the Act of 2017 had held that the period of 2 years as mandated was insufficient and the same and a period of 5 years was required to be granted to such candidates for acquiring the net/SLET/PhD qualification. Applying the said decision to the facts of this case, and also noticing the submissions made by Mr. S. Das that the petitioner had not acquired the said qualification within a period of 5 years. This court notices that the delay occasioning in acquiring of the said delay of more than 5 years occasioning in acquiring of the said course by the petitioner was actually was not on account of any fault on the part of the petitioner, but was on account of the delay in convening of the research advisory committee meeting after the petitioner had registered himself as a PhD student on 11/10/2019 and had submitted his and had received the satisfactory completion of his coursework, had received the report with regard to satisfactory completion of his coursework on 10/1/2021. It is seen that the meeting of the Research Advisory Committee was so convened only on 18/3/2021 on account of the fact that after the petitioner had completed his coursework, the COVID-19 pandemic had started and had stalled all such gatherings and had stalled কি লিখিছো আৰম্ভ কেনে কৈছো for 18/3/21. The delay in convening of the meeting of the Research Advisory Committee was on account of the COVID-19 pandemic prevalent at the relevant point of time. So, accordingly, it is seen that the petitioner had acquired his PhD degree after the initial registration within a period of 5 years. 5 years, how many months? You have written somewhere.
Question I have not made.
5 years, some months. 5 years, 8 months, and 21 days. So, the period of access period of 8 months, 21 days so required, being attributable to the delay occasioning on account of the COVID-19 pandemic situation prevailing at the relevant point of time after the petitioner had completed his coursework, the set period is required to be, this court is of the considered view that the set period is required, set excess period is required to be ignored. So, accordingly, the petitioner having completed his PhD degree course within a period of 5 years, the said degree would now be required to be reckoned by the respondent authorities for authorizing to the petitioner his pay and allowances in the UGC scale of pay prescribed for the post of assistant professor. So, in view of the above discussion, this court is of the considered view that the petitioner had fulfilled the condition as set out in had fulfilled the stipulation as set out in condition number 2 of the order dated 25/4/2018 on being awarded his on being held to be qualified for being awarded the degree of Doctor of Philosophy (PhD) by the Cotton University on 2/7/2024. Accordingly, the petitioner would be eligible to draw his pay and allowances in the against the post of assistant professor in the UGC scale of pay prescribed for the said post with effect from 2/7/2024. So accordingly, it is directed that the respondent authorities shall authorize to the petitioner his pay and allowances in the UGC scale of pay prescribed for the post of assistant professor held by him with effect from 2/7/2024. The areas of pay now required, now working out in favor of the petitioner with effect from 2/7/2024 shall be computed by the respondent authorities within a period of
2 months.
3 months, within a period of 3 months, and released to the petitioner after deducting the amounts paid to him as fixed pay with effect from 2/7/2024. Fuso. Within a period of area shall be released to the petitioner within a period after deducting so and so within a period of 3 months with effect from the date of receipt of a certified copy of this order along with a representation from the petition. So with the above observations and directions, the present petition stands disposed of. এই টিমন বলে নহলে মনত থাকিলে মই ডক্টৰ গলো এইটো হৈ গৈছে এইটো এলাও এইটো এলাও ডিছপ'জ কৰিছো ঠিক আছে বাকী পাই গৈছে এইটো এলাও এইটো মই খালি চাই দিব লাগিব দেই ওপৰত থৈ দিছো আৰু কি আছে B. Sharma. 17. B. Sharma. B. Sharma. Tare B. Sharma. Yes, Mr. Dhar, what are you waiting for?
I think this matter was called earlier, my lord. I was not.
Your lordship has already heard it. Your lordship has already seen the order, whereby lordship a punitive order was passed alleging misconduct without.
You have kept it. Oh, yes, 35%. Mr. Dhar was not here.
Yes.
So Dhar, what is this? My lord. What is this your recourse to? Is this the manner you pass an order under Rule 9, Rule 7?
My lord, they took this as a written statement, my lord. Yes.
Can you, when you have Rule 7, you must follow Rule 9 and you come to page
Page 30, that is the my lord show cause notice, my lord.
30. Show me under what situation I can deem this to be a show cause notice. You have said that this is with regard to his suspension.
My lord.
As to why your suspension should not be revoked before the inquiry committee to facilitate the inquiry without fail. And then you proceed to issue an order at page 34, terminating his services.
That, my lord, yes, to some extent, this is defective, my lord.
Not some extent. You are being too diplomatic.
But today he is saying that this order is
No, my, no, this,
Mr. Thor, don't worry, Mr. Thor. If something is there, I found him that he is the first one to point out.
Yes.
Yes, Mr. Thor.
my lord. My lord, this order says that, my lord, in para first, second, third, fourth. In the fourth para, my lord. And whereas the said committee examined the written statement of defense submitted by Sri Deepak Thapa.
That written statement is with regard to his suspension.
Relevant
Police document.
documents, including charge
We'll
sheet.
do one thing, we will interfere with this order and
we'll go, my lord, give us liberty.
say that he will be given the benefits, and you can always, you are at liberty to institute appropriate proceedings if so advised.
We will do it, my lord will give, give us liberty that we will go following rule 9.
You proceed.
My lord.
Sorry, proceed. Oh, it was Aru 40. Okay. There. We will pass the order. I'm having two more. Just pass that. You need not be here. I'll pass the. WPC 6095.
My lord will just give us liberty to go ahead.
With that, I'll.
Under the.
WPC 6095 2019. Item number 16. 16 to hotel law. 17 to copy paste to it. Heard Mr. I. Alop, Learned Counsel for the petitioner. Also heard Miss B. Sharma, Learned CGC, appearing for the respondents. Also, the petitioner in the present petition has presented a challenge to an order dated 30/11/2018, by which he was declared to be medically unfit for recruitment against the post of constable, for which he was selected in pursuance to a recruitment process held for the same. The petitioner hearing had appeared in a recruitment rally held during the year, held in the month of February 2018. Also, the petitioner had successfully cleared the his physical test, and thereafter had successfully completed the various stages of the selection process, but had failed in the medical examination held on 19/2/2018. The petitioner was thereafter referred to the 155 base hospital for review, wherein he was declared fit. The petitioner was then issued with an admit card for attending the All India Common Entrance Examination scheduled on 29/4/2018. The petitioner successfully completed the said examination, and his name found place in the merit list so published. The petitioner was thereafter provisionally selected for the post of constable general duty. In the said communication dated 31/5/2018, it was stipulated that his selection is subject to verification of his documents and being medically fit from a if required to be medically re-examined after 180 days bracket. So, as there was a delay in taking the procedure forward, comma, and more than 180 days having lapsed since the date of his medical examination during the recruitment rally and the date on which he was to be dispatched for training, comma, the petitioner was again subjected to a re-medical examination by the recruiting medical officer. So, on such re-examination of the petitioner was found to re-medical examination of the petitioner was found to be suffering from apostrophe varicose veins on his left leg, apostrophe over. So, the said disability being detected, the petitioner was forwarded to the senior recruiting medical officer, headquarters, headquarters recruiting zone, bracket Northeastern States, bracket over Shillong, for further examination. So, the petitioner was thereafter reviewed by the graded medic specialist surgeon at Military Hospital, Shillong, and he was then declared to be unfit on account of the said disability for being recruited to the force. So, being aggrieved, the petitioner has instituted present a writ petition. So, Mr. I. Alam, learned counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that the petitioner, at the time of his medical examination during the recruitment rally, was not detected to be suffering from any disability, including the disability of varicose veins on his left leg. Also, he submits that on account of a delay occasioning in the matter, comma, the petitioner was subjected to a re-medical examination. Also, on his such re-medical examination, the petitioner was declared to be unfit on account of having varicose veins on his left leg. It is submitted that the said re-medical examination done by the petitioner, on the petitioner, and the reports as obtained by the respondent authorities were so done behind the back of the petitioner, and the petitioner was not given an opportunity to, was not afforded with an opportunity to make a claim for being examined by a specialized civil doctor. Mr. Alam further submits that the manner in which the petitioner was subjected to a re-medical examination and the reports as obtained by him, as obtained in the matter by the respondent authorities, leading to cancellation of his candidature, comma, the petitioner was required to be given an opportunity to have himself medically examined by a competent, before a civil, before a competent doctor in the practicing in the civil side. So, accordingly, he submits that the that this court would be pleased to direct the respondent authorities to have a review medical examination of the petitioner, and by incorporating in the panel of doctors so prepared, a specialist from the civil side. So, per contra, Ms. P. Sharma, Learned Counsel for the CGC Learned Counsel appearing for the respondents, submitted that a lapse of more than 180 days having occasioned since the date of the medical examination of the petitioner during his recruit rally, the petitioner was mandated to be subjected to a further review medical examination in terms of the directives operating in this connection. It is submitted that the petitioner, on being examined by the recruiting medical officer, the petitioner was found to be suffering from varicose veins on his left leg. The petitioner accordingly was thereafter forwarded to the 155 base hospital for a further examination by a specialist doctor. The petitioner, on being examined by the specialist doctor at 155 base hospital, it was affirmed that the petitioner suffered from varicose veins on his left leg, and accordingly the petitioner was held to be unfit for recruitment to the posts. She submits that the said aspect of the matter was duly communicated to the petitioner via a communication dated 30/11/2018. So, Ms. Sharma submits that the disability detected in respect of the petitioner would have the effect of hindering the completion by him of his training program, and accordingly the petitioner was found to be unfit for recruitment to the posts. So she submits that the decision of the specialist doctor of the force, submits that the opinion submitted by the specialist doctor of the respondents, would require to be affirmed, inasmuch as only person fit in all respects would be permitted, would be mandated to be recruited to the posts. Accordingly, she submits that the rejection of the candidature of the petitioner would not mandate an interference from this court. I've heard the learned counsel for the parties and also perused the materials available on record. The petitioner was initially, during the recruitment rally, found to be on medical examination was found to be medically fit. However, on completion of the recruitment process and the petitioner having been placed in the merit list, the petitioner now being required to be deputed for training, undergoing training, a letter in this connection was issued to him on 31/5/2018. In the said letter, it was stipulated that he would be deputed for undergoing the training subject to verification of his documents and he being found physically fit for at the time of such of dispatch to the training center. A period of more than 180 days having lapsed since the petitioner was medically examined during the recruitment rally and the date on which the petitioner had appeared before the respondent authorities in pursuance to the communication dated 31/5/2018 for being dispatched to the training center, the petitioner was subjected to a review medical examination. The recruiting officer, medical officer, on examining the petitioner, found that the petitioner was suffering from varicose veins on his left leg. Accordingly, the recruiting officer referred the petitioner to the to 155 military hospital, base hospital of the force. The petitioner was examined in the medical hospital, in the 155 base hospital by a specialist, and it was affirmed that the petitioner was in fact suffering from varicose veins on his left leg. Accordingly, the specialist examining the petitioner opined the petitioner to be unfit for recruitment to the force. The said opinion having been received by the respondent authorities, the force authorities issued a communication dated 30/11/2018 to the petitioner, cancelling his candidature on being found to be medically unfit on his medical examination. While the petitioner has assailed the cancellation of his candidature effected by the communication dated 30/11/2018, which is based on the opinion rendered in the matter by the doctors examining him during his medical examination, the petitioner had not brought on record any material to demonstrate that at the relevant point of time, he had not suffered from any disability, including the disability identified by the doctors examining him during his medical examination. In the representation submitted by the petitioner, in the appeal submitted by the petitioner against the order date, against the communication dated 30/11/2018, also the petitioner had not highlighted the fact that the petitioner was not suffering from varicose veins on his left leg. Also, the respondent authorities having found that the petitioner having found the petitioner to be not suitable, not fit for recruitment to the force on account of suffering from varicose veins in his left leg, this court would not sit on appeal over such opinion rendered by a specialist in the matter, in absence of any material being brought on record by the petitioner to dispute the said opinion rendered in his case by the doctors examining him during his medical examination. It is a settled position of law that it is only a person found fully fit in all under all circumstances who would be eligible to be recruited to the post in question, and in the event any candidate is found to be medically unfit, it is not for this court to sit on appeal and substitute the views as opinion as rendered in the matter by a specialist, by the specialist of the force in question. So accordingly, the cancellation of the candidature of the petitioner being on account of a disability suffered by the petitioner, which was detected during his re-medical examination, this court is of the considered view that the communication dated 30/11/2018 would not mandate an interference from this court. Accordingly, the claim made by the petitioner in the present writ petition is held to be devoid of any merit, and the same accordingly stands, and the same consequently stands dismissed. 16 to Marile, 17 to Marile. Next case. So is Anigi? Mailo to not how to look. No, it to Mailo, it to Didi. It out of you. Kita go. The Kali boy. Kali kita. Yes. Total. Kita Kali boy. Kita sesama dia sudah. Ini motion kita puri kita tu. 49 to say. Oh, itu di. Itu item number 40, 38. WBC 463422. But Mr. P.D. Das, Learned Senior Counsel, assisted by Mr.
Jelothaluch.
D1000. You're D1000, no?
Jelothaluch.
J. Lotha, Learned Counsel for the petitioner. Also heard Mr.
P. Sharma.
Sharma, Learned Standing Counsel, not his.
No, Lordship, I am for RR question.
Speech Chakraborty was appearing.
P for respondent number 1.
I'm for appearing. Who was there yesterday? No. Also heard. She is there in the court today. Also heard Miss P. Chakraborty, Learned Standing Counsel, North Kachar Hills Autonomous Council, appearing for the respondent number 1, and Mr. C. Sharma, Learned Counsel, representing
respondent number 2,
District Primary Education Officer, NC Hills Autonomous Council, respondent number. The petitioner, the petitioner in the present writ petition has presented a challenge to an order dated 30/8/2024 issued by the respondent number 2, transferring and posting the petitioner from Choto, from Choto Longmailai, page 36 of serial number 18 of Pajavi, LP School 2, Long Renbra LP School. Also, as projected in the writ petition, also, Mr. P.D. Das, Learned Counsel, appearing for the Learned Senior Counsel, appearing for the petitioner, at the outset has submitted that the transfer and posting of teachers working in elementary as well as secondary schools is governed by the provisions of the Assam Elementary and Secondary Education Teachers apostrophe bracket regulation of posting and transfer bracket Act 2020. So, He submits that the procedure mandated to be followed for the purpose of transferring such category of teachers is laid down in the provisions of rule section 5. Of the said act. So, in terms, he submits that in terms of the provisions of subsection 5 of section 5 of the said act, comma, the district level committee as constituted in the matter in the district level committee as constituted in the matter is to first recommend the inter-school transfer of teachers within the district. After ensuring that the pupil teacher ratio is so maintained. Mr. Das, learned senior counsel, submits that in case of the petitioner, comma, in case of the transfer effected in respect of the petitioner, while the order dated 30/8/2024, the provisions of the Act of 2020 was not complied with. He submits that there is no recommendation made by the district level committee as mandated under the provisions of subsection 5 of section 5 of the Act of 2020 preceding the issuance of the order dated 30/8/2026, 30/8/2024. So, this court had raised a query with Mr. C. Sharma, learned counsel, appearing for the respondent number 2 as to whether the order dated 30/8/2024, insofar as it concerns the petitioner, was so issued after the due recommendation in this connection was received from the district level committee in terms of subsection 5 of section 5 of the Act of 2020. Mr. Sharma, in response on instructions, has submitted that there was no recommendation made by the said district level committee prior to, in respect of the petitioner, prior to issuance of the order dated 30/8/2024. The transfer and posting of teachers in elementary as well as secondary schools now being statutorily regulated by the provisions of the Act of 2020, such transfers would be required to be mandatorily effected only in compliance with the provisions of the said Act of 2020, and any violation of the provisions of the said Act of 2020 in effecting such transfers would render the such transfer null and would render the such transfers void ab initio. The transfer in respect of the petitioner admittedly having been effected while the order dated 30/8/2024 in clear violation of the provisions of the Act of 2020, the same cannot be sustained and would mandate an interference from this court. So, in view of the above conclusions reached by this court, the order dated 30/8/2024, insofar as it concerns the transfer effected in respect of the petitioner herein, stands set aside. However, it is provided that in the event there exists a necessity for transferring the petitioner to any other school, the respondent authorities are at liberty to issue orders towards transferring the petitioner to transfer the petitioner from her present school. However, such by strictly complying with the provisions of the Act of 2020. So, anything more is required? There is an interim order.
Yes, Lord.
The interim order passed earlier stands merged with the present order. With the above observations and directions, the present writ petition stands disposed of. এইকেইটা থৈ দিবা, কেতিয়াবা আহিলে লগা হয়। আৰু এটা উইন্ডোজ বেয়া পাব, বেয়া পাব। Mr. Borat, just give me the silent dates or the important dates. I forgot to make my note.
On 22nd of May 2023 was appointed.
22nd of May?
May 2023 was appointed as Chokidar, MTS, multitasking staff.
Appointed, the regular appointment.
Regular appointment.
As Chokidar, as MTS.
MTS.
In
Office of the Executive Engineer, PWD, Tinsukia District Territorial Building Division, Tinsukia.
Executive Engineer.
PWD, Tinsukia District Territorial Building Division.
Tinsukia District Territorial
Building Division.
Petitioner respondent number.
Lordship.
Then what happened? He was arrested.
Lordship, he was arrested on 16/6/2023. He was arrested in connection with Amren PS case number 14 of 2023. Immediately he was placed under suspension.
Amren PS case number
14 of 2023.
Under section
419, 468, 471 and 120B of IPC.
What was the allegation?
419, 468, 471 and 120B.
What was the allegation?
Allegation against him is that, Lordship, he forced some documents. Some other person forced some documents and he was one of the conspirator to that forgery. And that is why 120B is against him.
Then
suspension? On 16/6/2023, on the same day, he was placed under suspension. Then he got bail from this honorable court on 10/8/2023. He informed the authorities on 16/8/2023, which they denied. And then since subsistence allowance was not granted and his suspension was not reviewed, he approached this honorable court by WPC number 4th 4389/2025. So
then what happened?
There, Lordship, the matter was kept for instruction, and then in the meantime, the subsistence allowance was released.
What happened to that case?
Lordship, that case was disposed of because in the meantime, they issued the termination order.
Okay. Termination order is dated
18/11/2025.
Propose
4/10/2025.
Your reply?
14/10/2025.
This is the
That is all.
WPC 6825/2025, item number 35. The petition heard Mr. Bora, R. Bora, learned counsel for the petitioner, also heard Mr. R. Dot, standing counsel, Public Works Department, appearing for the respondents. So the petitioner in the present petition has presented a challenge to an order dated 18/11/2025 issued by the executive engineer, PWD, Tinsukia District Territorial Building Division, Tinsukia, imposing upon the terminating the services of the petitioner, invoking the provisions of Rule 7 of the Assam Services, bracket, discipline and appeal rules 1964. So, para. The petitioner herein was appointed, a petitioner on being selected by the State Level Recruitment Commission for Class 4 post was by order dated 22/5/2023, appointed as a Chowkidar bracketed multitasking staff bracket over in the office of the executive engineer, PWD, Tinsukia District Territorial Building Division. While the petitioner was continuing with his services in pursuance to the order dated 22/5/2023, the petitioner was involved in a criminal case being Hamred PS case number 14/2023, registered under section 419/468/471/120 bracketed B of the 120B of IPC. Also, the petitioner petitioner was placed under arrest in connection with the said case on 16/6/2023. The petitioner, consequently, the disciplinary authority of the petitioner wide order dated 16/6/2023 proceeded to place the petitioner under suspension. Also, the petitioner was thereafter enlarged on bail by this court, wide an order dated 10/8/2023, passed in bail application number 2350/2023. The suspension of the petitioner having been continued and the subsistence allowance of the petitioner not being released, the petitioner had approached this court. The petitioner raising a grievance in this connection had approached this court by way of instituting a writ petition being WPC number 4389/2020. Also, while the said writ petition was pending consideration before this court, the subsistence allowance of the petitioner was released to him. Also, a notice was issued to the petitioner on 4/10/2025, requiring him to submit written justification explaining the reason for his arrest in the criminal proceedings and to furnish details and present status of the police case registered against him. He was also required to adduce valid grounds for revocation of his order of suspension before an inquiry committee constituted in the matter. The petitioner thereafter submitted a reply to the said notice dated 4/10/2025. It is projected that the petitioner had also appeared before the constituted inquiry committee. So, the committee thereafter had submitted a report before the disciplinary authority of the petitioner. The disciplinary authority of the petitioner on perusal of the said report proceeded while order dated 18/11/2025. What is this order dated 26/9/2025 in the earlier petition?
That was directed for subsistence allowance.
Okay. While order dated 18/11/2025, concurring with the report of the said inquiry committee, proceeded to terminate his services by invoking the provisions of Rule 9 of the Assam Services (Discipline and Appeal) over Rules 1964. Being aggrieved, the petitioner has instituted the present writ petition. Also, Mr. R. Bora, learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that the termination / dismissal of the services of the petitioner was so effected by the disciplinary authority of the petitioner by invoking the provisions of Rule 7 of the Assam Services (Discipline and Appeal) over Rules 1964, hereinafter referred to as the Rules of 1964. So he submits that although the provisions of Rule 7 was so invoked for the purpose of dismissing the petitioner from his services, no proceeding as mandated under the provisions of Rule 9 of the said rules came to be instituted against the petitioner. He submits that no show cause notice in terms of the provisions of Rule 9(2) of the Rules of 1964 was issued to the petitioner in the matter, instituting a departmental proceeding against him. Mr. Bora, by referring to the notice dated 4/10/2025, has submitted that the same was so issued only in respect of the order of suspension issued in respect issued to the petitioner, and the same was not in connection with any charges framed against the petitioner as mandated under the provisions of Rule 9(2) of the Rules of 1964. Accordingly, he submits that the invocation of the provisions of Rule 7 for the purpose of terminating the services of the petitioner was so done in clear violation of the provisions of Rule 9 of the Rules of 1964, and accordingly, the order dated 18/11/2025 would not be sustainable. Per contra, Mr. R. Learned Counsel for the Learned Standing Counsel (PWD) has submitted that the petitioner was terminated from his services by following the required procedure prescribed under the provisions of Rule 9 of the Rules of 1964. He submits that an inquiry committee was constituted by the disciplinary authority of the petitioner for reviewing the suspension of the petitioner as well as for conduct of departmental proceedings. The said committee had duly examined the petitioner in the matter, and after examining the materials furnished by the police, by the investigating agency with regard to the criminal proceedings instituted against the petitioner, comma, the committee had recommended for the termination of the services of the petitioner. He submits that materials, adequate materials having come on record, demonstrating the conduct of demonstrating the commission of a misconduct by the petitioner in the matter, comma, the disciplinary authority of the petitioner on a consideration of all material of the materials, on a due consideration of the materials coming on record, including the statement of the petitioner recorded by the inquiry committee, proceeded with order dated 18/11/2025 to impose the penalty of termination from services of the petitioner. Mr. Dhar submits that the petitioner was actually imposed with the penalty of dismissal from service. Accordingly, he submits that the penalty of dismissal from service being imposed upon the petitioner on account of a proved misconduct, comma, the same would not mandate an interference from this court. I have heard the learned counsel for the parties and also peruse the materials available on record. The WPC 4389/2024, order dated 26/9/2025. They have themselves so fair. They have themselves said that there may be some lapses. We don't know how to do it.
Yes. And there was no person to conduct PP.
Is there a stay order operating in this one? And you say the respondents are not fair. They are, how?
No, he was defending that order on various occasions. That is why I submitted that. In fact, he also knows that the order is bad in law.
No, no, ito no, ito kaya pulo. You have given me a wrong number, I suppose. 4389.
Yes, 4389 of 2025.
25 also. This is some railway eviction bill.
$26,900.
Also, the petitioner here was in pursuance to the to a recommendation made in his favor, sit down, Mr. Bora. By the state level recruitment commission for class 4 posts, was appointed as a chokidar bracketed MTS in the establishment of the respondent number 3, wide and order dated 22/5/2023. So, while the petitioner was so continuing in his services, thereafter, the petitioner was attached to the election branch of the office of the Deputy Commissioner, Tinsukia, wide and order dated June 2023.
7/6/2023.
7/6/2023. So, the petitioner was thereafter released from his such attachment, wide and order dated 12/6/2023. So, the petitioner at the relevant point of time was arraigned as an accused in Amrit PS case number 14/2023 and was placed under arrest on 16/6/2023. The petitioner having been placed under detention on 16/6/2023, the disciplinary authority of the petitioner, that is the respondent number 2, wide and order dated 16/6/2023, proceeded to place the petitioner under suspension until further orders. Also, thereafter, the petitioner was enlarged on bail by this court wide order dated 10/8/2023 in bail application number 2350/2023. The petitioner has projected that he had informed his disciplinary authority via a communication dated 16/8/2023 about his release on bail, or about his enlargement on bail by this court. However, the said position is disputed by the respondent authorities. Being aggrieved by the prolonged suspension occasioning in his case, as well as non-release of his subsistence allowance, the petitioner had approached this court by way of instituting a writ petition being WPC number 4389/2025. A coordinate bench of this court wide order dated 26/9/2025, while requiring the respondent authorities to release to the petitioner his subsistence allowance, had required the counsel representing the respondents to receive up-to-date status with regard to the disciplinary proceedings, if any, instituted against the petitioners, against the petitioner hearing. Also, in pursuance to the passing of the said order, the disciplinary authority of the petitioner, that is the respondent number 2, while order dated 14/4/10/2025, issued a notice to require the petitioner to submit a written justification and appear before the inquiry committee as constituted in the matter and to place grounds for a revocation, place grounds before the said committee, places some contentions before the said committee for revocation of his suspension. The petitioner accordingly submitted his written statement before the disciplinary authority on 14/10/2025, denying involvement in the allegation, denying any involvement with the allegations as existing in Hamrin PS case number 14/2023. The petitioner also projects to have appeared before the inquiry committee as constituted in the matter. The inquiry committee, on conclusion of the inquiry conducted, submitted its report in the matter. Also, the inquiry committee concluded that the petitioner at the time of his arrest was on probation and was named as an accused in Hamrin PS case number 14/2023. Accordingly, the inquiry committee recommended that the petitioner be dismissed from government service in view of his proved misconduct. Basing on the said recommendations of the inquiry committee, the disciplinary authority of the petitioner, that is the respondent number 2, proceeded by order dated 18/11/2025 to impose upon the petitioner a penalty, to proceeded to terminate the services of the petitioner, invoking the provisions of Rule 7 of the Assam Services (Discipline and Appeal) over Rules 1964.
Respondent number 3, Lordship.
Respondent number 3. Pusa. The petitioner was held to have been dismissed from government service with effect from the date of issuance of the said order. The disciplinary authority of the petitioner, having invoked the provisions of Rule 7 of the Assam of the Rules of 1964 for the purpose of terminating the services of the petitioner, this court would now examine the provisions of Rule 7 of the Rules of 1964. Rule 7 of the Rules of 1964 mandates that mandates the penalty which would be permissible to be imposed upon a government servant on a government servant. Also, Rule 9 of the Rules of 1964 mandate that any penalty specified in Rule 7 shall be permissible to be so imposed after an inquiry, held as far as may be in the manner provided therein. Rule 9(2) mandates that the disciplinary authority shall frame definite charges on the basis of the allegation on which the inquiry is proposed to be held. It further stipulates that such charges, together with the statement of allegations on which they are based, shall be communicated in writing to the government servant, and the government servant shall be required to submit, within such time as may be specified by the disciplinary authority, a written statement of his defense, and also to state whether he desires to be heard in person. Accordingly, On a conjoined reading of Rule 7 and Rule 9 of the Rules of 1960, it is seen that a proceeding under Rule 9 is mandatorily required to be instituted and concluded before a penalty is penalty specified under Rule 7 of the said rules is permissible to be so imposed upon a delinquent. In the case on hand, the purported initiation of the disciplinary proceedings against the petitioner is projected to be so done while issuance of a notice dated 4/10/2025. On a perusal of the said notice dated 4/10/2025, this court does not find that the same was so issued invoking the provisions of Rule 9 bracketed 2 of the Rule 9 of the Rules of 1964. This said notice was only in respect of the order of suspension issued in against the petitioner, and the petitioner was called upon by the said notice to urge grounds for revocation of the same. The said notice cannot under any circumstances be construed to be a show cause notice issued complying with the provisions of Rule 9 bracketed 2 of the Rules of 1964. The notice dated 4/10/2025 being not a notice as contemplated under the provisions of Rule 9 bracketed 2 of the Rules of 1964, no departmental proceeding can be inferred to have been can be held to have been instituted against the petitioner hearing. Accordingly, the disciplinary authority of the petitioner did not have cannot be held to have had the jurisdiction to invoke the provisions of Rule 7 of the Rules of 1964 to impose upon the petitioner any penalty as specified therein. This court finds that the disciplinary authority of the petitioner, while the order dated 18/11/2025 had considered the report submitted by a departmental inquiry committee, which had held that had stipulated that in compliance with an order dated 26/9/2025 passed by the honorable by this court in WPC number 4389/2025 had constituted a departmental inquiry committee to review the suspension of the petitioner and to conduct departmental proceedings against him. From the materials brought on record, it is seen that only a review of the suspension of the petitioner was carried out by the inquiry committee so constituted, and no departmental proceedings came to be instituted against the petitioner in the matter. Further, the said inquiry committee cannot also be held to be a committee as constituted by the disciplinary authority in terms of the provisions of Rule 9 bracketed 4 of the Rules of 1964. The said committee, in the considered view of this court, was a committee only constituted to carry out a preliminary inquiry in the matter and nothing further. Accordingly, the report of the said inquiry committee cannot be elevated to one submitted in terms of the provisions of Rule 9 bracketed 7 of the Rules of 1964. Accordingly, the said report submitted by the inquiry committee could not have been reckoned by the petitioner, by the disciplinary authority of the petitioner, for the purpose of imposition of any penalty specified under the provisions of Rule 7 of the Rules of 1964 against the petition, upon the petition. So accordingly, the order dated 18/11/2025 issued by the disciplinary authority of the petitioner, imposing upon the petitioner the penalty of dismissal from service, in the considered view of this court, has been so issued without jurisdiction and in clear violation of the provisions for conduct of a departmental proceeding as contemplated under the provisions of the rules of 1964. At this stage, this court would notice that in the affidavit filed in the present writ petition by the respondent authorities, it was categorically contended that some procedural lapses might have occasioned in the conduct of the proceedings in the matter against the petitioner due to the fact that the division was newly created and majority of the staff were recruited only in the year 2023 and no experienced personnel were available to handle such a departmental proceeding and court-related cases. It was further contended in the said affidavit that there was no witness available to depose in the matter against the petitioner, and there was also no documentary evidences available, as all such documents were seized by the Amren police in connection with Amren police case number 14/2023. The said contentions made by the respondent authorities in the affidavit further goes to fortify that there was in fact no departmental proceeding instituted in the matter against the petitioner, and the order dated 18/11/2025 was so issued without jurisdiction by the disciplinary authority of the petitioner. In view of the above conclusions reached by this court, as well as the reached by this court, the impugned order dated 18/11/2025 is held to be not sustainable, and accordingly, the same stands set aside. The petitioner, the next time, this court having interfered with the order dated 18/11/2025, the respondent number 3 is directed to forthwith reinstate the petitioner in his services. So, a departmental proceeding having not been instituted against the petitioner in the matter till date, in terms of the provisions of the rules of 1964, this court directs that within a period of 1 month from the date of receipt of a certified copy of this order, the respondent authorities, more particularly the respondent number 3, shall take a decision basing on the materials available on record as to whether a misconduct, whether commission of a misconduct by the petitioner in the matter is discernible therefrom. In the event the respondent authorities, including the respondent number 3, is of the view that a misconduct is discernible in the matter against the petitioner, the respondent authorities shall, within the period of 1 month as permitted by this court herein above, institute appropriate departmental proceedings against the petitioner strictly in accordance with the provisions of the rules of 1964. Also, the period with effect from a period with effect from 18/11/2025 till the date of passing of the present order till today, That is agitated to DDS. Huh? During which period the petitioner had to remain out of service on account of the order of dismissal imposed upon him shall be regularized after completion of the departmental proceedings. Now, departmental proceedings by acting upon the liberty granted to the respondent authorities to institute such proceedings by this court herein above. In the event no such proceeding is instituted against the petitioner within a period of 1 month from the date of receipt of a certified copy of this order, the period of absence of the petitioner with effect from 18/11/2025 till the date of his reinstatement in terms of the directions passed herein above shall be regularized as on duty, and the petitioner shall be released his salaries for the said period. Further, the period of suspension of the petitioner shall also be regularized as on duty with release of his salaries after deducting the subsistence allowance already paid to him. With the above observations and directions, they present. My dear Lordship.
Somewhere your lordship observed that he was on while order dated 12/6/2023, the petitioner was released from the attached post, but he was released from the original post to join the attached post by order dated 12/6/2023.
I'll check out. Yes, Mr. Muzumdar. Huh? On any. Mr. Counsel, you are there? Mr. Chaudhary is not online.
My lord, if I may be allowed to inform him.
Yes, Mr. Muzumdar. This will take some time.
This will take some, the issue is a very
ticklish one.
Very, very minor. In fact, I, at one point of time, I made a submission before this court that this is a issue, particularly the interpretation and the definition of original inhabitant of Assam, if required to be addressed, is for the government to define. Now, in view of the present or in view of the circumstances prevailing in Assam, this has various implications. Otherwise,
he was originally a resident of Rajasthan, married an inhabitant of Assam.
Prior to this, my lord,
what is your interpretation of an original inhabitant of Assam?
That's what I was saying, my lord. Very difficult. As a counsel, I cannot make my own submission and say that.
No. But what is the stand of the respondents?
My lord, there are two things. If your lordship goes to the rules, which your lordship will find in our affidavit filed on 9/12/2024, running page will be possibly by 104. Start from 103. This is the rule, my lord, 90th notification of 19 December 2022. These rules may be called Assam Public Services Combined Competitive Examination Amendment Rules 2022. Now, if your lordship goes to substitution in, this is an amendment actually. In the principal rules for the existing rule 5 of schedule 2, the following shall be substituted, namely 5A, it's all like 5B.
See,
A candidate, I'm just showing first 5B, my lord. A candidate should be able to speak SMS or other official language or associate official language of the state or any of the tribal languages of the state. Now C is important. A candidate should be registered in a district employment office of Assam. And lastly, my lord, D, a candidate must be an original inhabitant of Assam.
the
So for-
advertisement was issued after this.
after this.
Where
Now,
is-
the advertisement you'll also will find at page 31 of the
31.
writ petition. And at page 36, my lord, the relevant portion.
Now, did she give a district employment registration certificate?
That she has given, but under the existing rules and the office memorandum, she is not entitled to be registered.
Why?
It says, well, these are the recent. Earlier, we annexed certain documents to show that she has to.
It's already 4:10.
Well,
It will be difficult for this court to now.
My lord. This basically says the person has to.
Where is Mr. Chaudhary?
My lord, he is appearing.
I think.
I'm there. My lord. My lord, this issue of district employment has come later. Now they're trying to make the case different. And even otherwise, that's not a rule, neither an act or nor any cabinet decision. It's just a user manual which has been annexed.
When there is nothing, that will be the executive instruction that will hold the field.
No, my lord, that is not even an executive instruction. That's a user manual. Nothing is, that's not a.
There are executive instructions. Now we have come up with documents to show that there are executive instructions.
There would be, there is I remember there is something. But this registration of employment, you just check up, there is something.
Well, today I have, my learned friend has supplied these documents along with that notification, etc.
You give a copy to them also.
Yes, and possibly we need to bring it on record by filing an affidavit, possibly. My learned friend has got only, I think, yesterday.
No, you will have to, these are user mail, as Mr. Chaudhary has submitted, this will not do. Where is that? You may not have a rule, but there is a employment. When were you married, Mr. Chaudhary?
2013, my lord.
2013.
Yes, sir.
And the recruitment is of 2020?
22.
22.
Lord, may I just say one thing? Initially, it was only with respect to that original inhabitant. Firstly, they said permanent resident. That certificate is not there.
Original inhabitant, you have cleared the SMS paper also.
Yes, we have no. There is no SMS paper, but there is an oral conversation in the interview. SMS questions have been asked, and
That
it
was
is
cleared.
specifically stated she has cleared it. She ranked 35th. She has ranked 35th. So that was not even the issue of knowing SMS or not.
You mean to say that she has to be deemed to be a original inhabitant because her husband, she does not have a status on her own.
Yes.
Because of the husband being a original inhabitant of the state.
That is how she has perceived it. She understood it. But now, when the government is coming and saying that she is not the original inhabitant, now her question is then who are original inhabitant? Because there is no definition as such. If the government say 20 years, that will create a massacre for the government. That if 20 years a person stayed in Assam for 20 years, if started treated like an original inhabitant, that will be also a problem. If the government say
20 years concept is different. 20 years concept comes from the guidelines pertaining to issuance of permanent residency.
absolutely. Now PRC is for education purpose.
For being
You
eligible
cannot-
to be registered with the district employment exchange.
No, my lord, this district employment, let me come at a later stage, but PRC, that's a higher education purpose.
I'm not on that.
PRC is not
PRC
applicable to
that
everyone.
Concept is found there also.
Yes, that PRC is totally different, but that will not give a idea of original inhabitant. Because the moment the definition
Mr.
of
Chaudhary, one thing, because this issue, we'll have to be very careful because
absolutely, my lord.
any opening would also demolish the intention
No.
behind that amendment?
I'm not saying, my lord, what I'm saying, what I'm trying to say, I'm not, what my suggestion is, here in this case, when there is no meaning given of original inhabitant, rather than opening the issue, rather it can be kept in a safeguarded way that even the meaning is not given when the definition itself is vague. Why to restrict this lady? Because it is not a case that some outsider had come and got her appointment. She is married here in Assam for last 10 years. So that way, because the definition is itself vague. And that will be directly hit by Article 14 because that is not applicable, made applicable for other candidates.
No, your passport is still of Rajasthan.
No, passport is also of Assam.
No.
No, everything is of Assam. I have annexed the passport. My voter ID, my passport, my Aadhaar card, everything is of Assam. My husband definitely had PRC. I have annexed the PRC document of my husband also.
No, there is no dispute with regard to your husband.
Yes, my lord. My lord, kindly see the passport. It is in page 24 of the writ petition.
And a passport.
You bring on record whatever you want.
My lord, I will bring on.
My lord,
In fact,
this has been,
we are.
I'm just requesting one thing, my lord. This has been 4th or 5th time. On the last occasion also, my learned senior will agree to that. On last 2 occasions also, because of filing this document only, time was taken. Previously also, one affidavit was filed and subsequently again another affidavit was filed. And government has specifically stated that there is no meaning given to original inhabitant.
Mr. Mujumdar.
My lord.
These are official documents. These are
Yes.
documents which are there in public portrait.
Yes.
Do one thing. You make a compilation, give it to him. Give it to Mr. Chaudhary.
In fact, we are
delay by filing affidavit.
Yes.
Because the last date, the order is that attempt will be made to dispose of the matter on today. So, okay, fine. If
In
you
fact,
have something,
we are
it's also already
yes,
time also.
and we are expecting 1 or 2 more documents. In the meantime, we'll furnish all. This,
Okay. When do you want this matter to be listed?
Let me be very specific. So far as the first issue is concerned, some documents have come, we'll furnish.
Mr.
So far as the
Mujumdar, please use your discretion.
My lord.
Take a last chance.
My lord,
and we have fixed the matter on that day. I'll make it very clear that there will be no further action.
My lord.
Tied up this court, maybe, I don't know. Let's see. You give me a date. Mr. Chaudhary, you are here on 4th or 6th. Not here. You will be able to join in on 4th or 6th online also.
My lord, I can come if Lordship records and no further adjournment will be given. I'll come on physically.
Now we are also attuned to online hearing.
My lord.
4th on 4/8.
Absolutely.
So,
In fact, may I say,
here now, heard Mr. K. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. D. Mujumdar, Learned Additional Advocate General, assisted by Mr. J. K. Goswami, Learned Additional Senior Government Advocate, appearing for the state respondents. Mr. Mujumdar has submitted that the respondents have furnished to them. The Learned Counsel for the respondents have submitted that the respondents have furnished to them certain documents, which were certain documents with regard to the manner in which a citizen residing in the state can get his name recorded, registered in a district employment exchange of the district and employment exchange situated in the state. He submits that the said documents would be vital or would be mandated to be considered by this court with regard to appreciate the contentions raised by the petitioners in the matter, by the respondents in the matter. So, considering the said submission, this court adjourns the matter today. The respondents shall file an affidavit in the matter, bringing on record the said documents without fail on or before 29/7/2026. No further adjournment shall be granted for the purpose to the respondents. In the event the said affidavit is not permissible to be filed, the documents sought to be relied upon shall be placed before this court on the next date. However, copies of the same be furnished to the learned counsel for the petitioner on or before 29/7/2026. Registry to list this matter again on 4/8/2026, as has been agreed to by the learned counsel for the parties. No further adjournment shall be sought for in the matter by either of the parties.
Highly obliged.
Done.
Highly obliged.
You can keep this back. When you give it the compilation, you give it to.
I was saying, my lords, this technology is more advanced, it seems, in the very nice sound also coming. The sound is coming very nicely, lordships.
It's good.
Highly obliged.
Earlier, I had some difficulty. Now I am accustomed to this.
I guess the Wi-Fi has also been better now.
But Wi-Fi, now I am getting it here. Earlier, I was not getting.
Quite
Now
better. Yes, lordship. Highly
we
obliged.
are also coming up, Mr. Chaudhary.
We are following your steps only, my lords. Obliged.
Deeply obliged, man.
Okay, this matter pertains to termination.
Today, it will not be possible.
Not be possible, my lord.
As agreed to by the learned counsel for the parties, registry to list this matter again on 6/8/2026. Davinder.
Yes, my lord, that covers me.
I had my one order. I passed an order. Davinder, following Davinder.
I'll check.
Yes, Mr. Chutia, what is that?
Maybe take it up next week, my lord.
No, next week, the week next, all tied up. She will not permit. So I can't. So we'll have to have it on the 6th, 6/8. Heard the learned counsel for the parties. Hearing remains. Who is there for the item number 49? You will appear?
Yes.
What, do you have anything to submit? Submit done. Heard the parties at some length. Hearing concluded. Registry to list this matter again. 23/7/2026 for delivery informs. That's order is ready. I have to just polish it. I'll deliver. Argument.